My please, Your Lordships. My Lord, with the consent of the other side, I beg to mention item 7. Here, Lordship, I was appointed as a counsel for respondent number 2, legal aid counsel. But unfortunately, I haven't been served with a copy of the paper book yet.
Okay.
I'm Procedural.
Then who is the counsel for the appellant? Yes. So we'll have to adjourn the matter then,
Yes.
isn't it?
Next week.
Yes, the learned counsels for both the parties are present. While Miss,
And Duncan,
yes, and Nangan, learned legal aid counsel for respondent number 2 submits that copy of the paper book has not been furnished to her and she has prayed for adjournment. Accordingly, registry to do the needful and furnish copy of the paper book to the learned legal aid counsel for respondent number 2.
maybe
Let's
taken up
the
next week.
matter- After 2 weeks? After 2
Yes,
weeks.
Oblige.
Oblige.
May I please? Your Lordship, I beg to mention item number 4 for withdrawal here. I have filed this IA for the implement of the respondent number 2 hearing. However, after filing of this IA, the respondent number 2 has been transferred now again. So I will be filing a fresh IA.
Okay. Heard Mr.
IBAM.
R. Barman?
IBAM.
I. Barman.
BAM.
Okay, Bam. Learned counsel for the applicant who submits that he may be allowed to withdraw the instant interlocutory application and file a fresh IA since the concerned incumbent in the IA has also been transferred. In view of the above, the IA is allowed to be withdrawn with a permission to file afresh. Accordingly, IA number 150/2024 stands disposed of on withdrawal.
Item number 1.
Yes,
May I please, ma'am? My lords, this is a public interest litigation which has been filed to, my lords, bring before my lords the affairs of the Panchayati Raj, for which a constitutional amendment was actually introduced in the year 1993 and by the Article 243. The sorry state of affairs of Panchayati Raj have been, my lords, in this PL pointed out in 4 major points. First, my lords, is that certain provisions of this, there is an act of 2018, which, my lords, is ultra vires the provisions of 243G, wherein certain additions have been made or certain conditions have been placed in section 142(7). Hereby, there is an
what is the
introduction.
name of the act?
That is the act Arunachal Pradesh
Actually, more email ID login corporation.
APL, Arunachal Pradesh Panchayati Raj Amendment Act 2018. In this section 142 subsection 7 is ultra virus. That's the first issue which has been raised, my lords, because it introduces a concept of non-elected bodies, which is specifically prohibited by the Constitution.
Where's that? Take us to the act.
It's I would, my lords, point out the page numbers. At page 244, if your lordship would have.
244.
Yes, my lords.
Okay.
Which is annexure 6. Your lordships, that's the page which starts, and at page 246, if your lordship would have, this is the 24th introduction. May I read?
Yes.
In the Panchayati Act, in section 142, the words or Anchal Samiti Anchal Samiti and Anchal Samiti, wherever appears, shall be deleted. In section 142, now this is ultra virus, if I would submit to your lordship. This is in section 142 after subsection 6, the following provisions shall be inserted, notwithstanding anything contained in article in the act, in case the Zilla Panchayat or Gram Panchayat are not reconstituted in terms of this act, and in case the Zilla Panchayat or the Panchayats are dissolved due to compelling circumstances, the functions of Zilla Panchayat and Gram Panchayat shall be vested to such competent authorities as may be determined by the government to ensure the interest of public are protected. During the transition period, the new Zilla Parishad and Gram Panchayats are reconstituted under the act. Now, this is in contravention of your lordship's 243G. Your lordship would have 243C of the Constitution, which is at page, I have reproduced that at page 112 of the petition. (112), if your lordship looks at. May I?
C.
My lords,
243C.
my lords. Subject to the provisions of this part, the legislature of a state may, by law, make provisions with respect to the composition of panchayats. I will skip the proviso, Article 2. All seats in panchayat shall be filled by persons chosen by direct election from the territorial constituencies in the panchayat into territorial constituencies in such manner that the ratio between the population of each constituency and number of seats allotted, which shall be, that's not important, but the direct election part is what is in direct contravention, that 142(7), and then your lordship would also have 243I, that is at page, I'm sorry, it's not, but 243.
What, page 115?
Just one,
I.
my lords. E first, I'm so sorry.
E.
That is at page 114. Every panchayat, if your lordship has at page 114E. This is titled as duration of panchayat at the precedent. Every panchayat, unless sooner dissolved under any law for the time being enforced, shall continue for 5 years from the date appointed for its first meeting and no longer. No amendment of any law for the time being enforced shall have the effect of causing dissolution of a panchayat at any level, which is functioning immediately before the amendment till the expiration of its duration specified in clause 1. Now, 3 is important if your lordship will have. An election to constitute a panchayat shall be completed before the expiry of duration specified in clause 1. Before the expiration of period of 6 months from the date of its dissolution. So before the panchayat actually dissolves or completes its term of 5 years, your lordships, 6 months prior to that, a new panchayat has to be elected. Now, 142(7) is in direct contravention of these two provisions. That's the first prayer. Second is, there is another mandatory provision which is not being followed in Arunachal Pradesh, and that is at page 115, 243G. And that is constitution of (243G and I). Subject to provisions of this constitution, the legislation of a state by law endow the panchayat with such powers and authority as may be necessary to enable them to function as institution of self-government, and such law may contain provisions for devolution of powers and responsibilities upon panchayat at the appropriate level, subject to such conditions as may be specified with respect to, and there are various aspects. This is a prayer, which is third prayer, I'll come to that later, but prayer, second major prayer, your lordships, is at 243I. That is constitution of a state finance commission. In Arunachal Pradesh, unfortunately, your lordship, state finance commission has not been constituted, and therefore the panchayats are functioning dehors the mandatory provisions of the constitution itself, let alone the law which has been formulated in this regard. If your lordship would have 243(1), 343I, the governor of a state, my lords have it. Do my lords have it? 243I?
Yes.
1. The governor of a state shall, as soon as may be, within 1 year from the commencement of the Constitution, 73rd Amendment, Act 1992, and thereafter, at the expiration of every 5th year, constitute a finance commission to review the financial position of panchayats and to make recommendations to the governor as to, then there are various provisions which have to be followed. And the very first, the principles which should govern is the distribution between the state and panchayats of the net proceeds of the taxes, duties, tolls. All these things have to be conducted, my lords, at the level of State Finance Commission, which is non-existent. That's the second prayer. I will take my lords to the prayers also. But another aspect, my lords, which has been highlighted is that there is a 14th law commission which has been constituted under Article 280 of the Constitution, and a 15th law commission. Both of them have been constituted, and the 15th law commission, your lordships, the period of the 15th law commission is from
Law commission.
of the center. Law commission, finance commission.
I think it's finance
Finance.
commission, huh? That's
My
right.
mind.
14th and 15th finance commission.
Finance commission.
Yes.
The duration of 15th finance commission, your lordships, is from 2021 to 2026.
26, huh?
The mandatory requirements of the finance commission also, which I have pointed out in my petition also, are that every expenditure has to be routed through the panchayat and within a time span of 15 days.
Hmm.
All the grants received from the center as well as the state grants have to be routed through the panchayat. Now, this has not been followed. That's the third major prayer, for which I have adduced various proofs in my petition that this is not being followed. Fourth aspect, your lordships, is of corruption. I have collected proofs and I have attached them also, that the money is being spent and was spent actually during the period of 2018 to 2020, when there was no panchayat at all. So all the money which was spent then is actually misappropriation of funds, and all the monies which have been spent dehors or disregarding the provisions of 14th Law Commission, Finance Commission, I'm so sorry, and the 15th Finance Commission are again misappropriation of funds, simplicity.
And the amount?
Amount runs into hundreds of crores. I have illustrated that also, for which I have also, my lords, 2 FIRs have been filed till now, but no action is being taken on them. Amounts would be, my lords, in the first FIR which was registered, was about for one district only, Kara Dadi district, of 41 crores, which is annexure 3 P18 at page 316. Second FIR, my lords, is qua 455 odd crores. This is FIR number 14, which is annexured at 314 page and which is annexure 17.
So there has been filed, so there's a criminal case pending.
This is one aspect, as I was respectfully submitting. This is the last aspect, but these are constitutional issues which, my lords, have to be, my lords, addressed by my lords only. There is no other authority which can, my lords, now address them, because there is violation, clear-cut violation of the Constitution by the introduction of section 142(7). B, there is no State Finance Commission. C, my lords, the provisions are not being followed despite our repeated requests and representations. The fourth aspect, my lord, to that extent, I would submit my lord has a point in there, and I bow down to that. But the point remains, the FIRs have been lodged in the years 2022. No action till date.
2022 FIR.
First, that was FIR number 10.
Against certain government officials.
I'm not
Who are
against
the-
just government officials, but private individuals also. On law, there is also extreme clear if government servants and private parties are both the accused, then sanction can be had at any stage before taking cognizance. So I would
So the FIRs which you have filed, you said it's against certain government officials.
also.
So now the instant PIL, who are the respondents?
Respondent bullets are respondent number 1 is State of Arunachal Pradesh through its Chief Secretary. Respondent number 2 is Union Ministry of through Finance Department, which is responsible for distributing the money, because now the law as it exists is further amounts cannot be granted by the Central Finance Ministry also if there is no certificate of following the guidelines of the 15th and 14th Finance Commission. So respondent number 3, Your Honor, is Ministry of Panchayati Raj, which is the nodal ministry actually of Panchayati Raj in the Union of India. Fourth is Secretary Department of Panchayati Raj, Government of Arunachal Pradesh. And then, of course, the Controller and Auditor General of India. Because
You have
it's
made the CBI also, the
yes, plus
respondent.
because
What?
that is my respectful submission.
Huh.
That the investigation, because it involves such senior officials, will not be possible at the level of local police. That's the reason I'm troubling my lords on the fourth prayer also. Otherwise, I would not trouble my lords on that.
To hand over the matter to the CBI if it's possible, is
that-
it?
Yeah,
Oh.
if your lordship considers it
After
appropriate.
hearing the
Of
respondents.
course. But the reason for my troubling my lords is only that, because it has been demonstrated by the records which I have placed before my lords that local police is actually not able to, if I can use that term, investigate about the crimes of such senior functionaries of their own government.
And who is the instant petitioner? What
Let's
is
see,
his address?
he is a lawyer and a very hardworking actual social worker, and he's been also assisted by 2 former student leaders who are actually helping him in collecting the evidence and various RTIs they have filed. Plus, they have also gone down to the to various places physically to collect various evidences. And let's would see that the petition runs into hundreds, if not thousands of pages, and all that is evidence which they have collected. So that, my lords, we can establish a very strong case for my lord's consideration.
You wish to note it?
Yes, sir. You have clubbed too many cause of actions. Isn't it?
That's, the subject is one.
Not
With utmost of
intrinsically
respect.
connected. How a PIL is maintainable against challenging a act?
But it's a repetition also, if you're
No.
not. Please.
This is a
How
PI.
a PIL is maintainable against challenging a rule or an act?
Let's,
You satisfy us on that. There are judgments of the Supreme Court clearly says that don't entertain PILs challenging act and rules. Number one. Number two, so far relating to the Constitution of Finance Commission under 247I, that can be a ground or a subject matter of PIL. No issue. This is a separate issue that Finance Commission is not established. One is challenge to a provision of the Act. This is another cause of action. Third is corruption. How will you deal with all this?
let's why I have pointed out, if your lordship also has been pleased to, that this formation of a finance
yes,
commission
we
is
can
one aspect.
issue a writ of mandamus in a PIL saying that this is the mandate of the Act, so you do this. We can strike down a provision of law, legislation, when the conditions are fulfilled, violation of part 3 of the Constitution of India. And other aspect is a inquiry in corruption in different cases. How these three things are clubbed together? How will you entertain this repetition?
Let's, because of
PIL.
not,
PIL, how
It's a
can,
PIL.
how can we? Yes, a CBI inquiry, if there is a important, if we prima facie show us that there are corruption channel, okay, we can issue a notice at this stage. Then regarding the challenge to a rule, again, it is a different aspect altogether. Whole plank of argument will be different. Whole cause of action is different. How these two are related, corruption and the challenge to the rule. And who are you? You file a writ petition challenging that rule. What is the judgment, Mr. Recent judgment of Supreme Court?
let's, if, well, instance,
No.
my lord
There-
is,
Based on judgment 1981 lordship. Yes.
So there is a recent judgment where it says, please do not, High Courts should not entertain PIL so far relating to challenge to legislative action.
let's, with utmost of respect at my command, there is no absolute bar. It's just, if I can, I
There
have,
is no absolute bar. In exceptional circumstances, yes, that judgment itself says.
yes,
But we do not think this is a clubbing
But
of
that-
too many cause of
that-
actions. We will
that,
not be
that I
able
bow
to
down to.
handle this.
Let's, I can drop that aspect of the constitutional challenge at this stage, and I will,
Not at this, we'll record it. That constitutional challenge is given. That part is closed.
let's but subject to my rights and contentions, if I want to file another petition,
That will be a different cause of action.
that is fair.
This, you drop these two issues with a liberty.
Which is the second
then-
issue, my
then
lord, is,
You drop these two issues so
Oh.
far relating to challenge to the rule as well as constitution of commission. You file separate petition with liberty. We may issue a notice at this stage, not to all the respondents, but
Oh,
to
okay.
certain respondents.
Since there are going to be a lot of changes
Yeah.
in the PIL, won't it be much easier
To
if
withdraw and
we
file separate.
withdraw the extent PIL and file a separate PIL and maybe a writ petition that
Separate.
separately?
Let's-
Instead of, because then
You have
again, the
instructions
parties
from
will
it.
have to be dropped, some of the parties will
Let's-
have to be
what-
dropped.
no,
Then recast, yes, recast of the whole thing will have
No,
to be done.
parties, with utmost and greatest of respect, most parties will not have to be dropped, because the last two aspects, which my lord is also of the opinion, that can continue.
The
in this.
parties
Let's
need
see,
not be,
let's see.
but the parties need not be, but.
My lords may issue notice to certain parties.
No. It is, we are not.
See, it will be lesser of a homework for the other benches also, because it's not going to be
The state
complete.
will have
No.
to answer on three aspects in an affidavit. We suppose we think that there are problems, then we will have to monitor it. In a given criminal case, even if we are not there, if we are satisfied that yes, there are corruptions, we might monitor in a PIL. No doubt about this. But what about these legal issues of that?
That, my lords, I am already
The
saying that I
amendment
will.
of the
Therefore, it's up to you. We have
But I-
expressed our view.
Because I am
You
willing,
have two options, either you have your instruction from your client today, or you withdraw file with a liberty, all this, that's all.
may I just propose?
If you
fair enough.
proceed, we can dictate this order, no issue, no problem on that.
May I
It will
just,
take 5 to 7 minutes.
may I just propose
Yes.
this? As my lord's earlier proposal, it will save a lot of time of the judiciary also and from our side also. If your lordship can pass an order, I will withdraw these two prayers of Constitution of a State Commission as well as State Finance Commission as well as of the challenge to 142(7). Rest, if your lordship can issue the notice, I will be, I'm in my lord's hands. I fully agree with it, that will unnecessarily complicate.
this-
I fully agree with my lords, and it's rightly guided us to do in a proper manner. I would say that.
So we would suggest you withdraw the PIL
File.
and file afresh. That would save a lot of paperwork also. Okay, because when we are
Because
going
these
to.
pleadings
issue
are already
notice- No,
structured in challenging 3 issues.
I just feel only, I will have to
You see,
bother
we
my
can
lords once
do
again.
that.
That's the only concern. I'm willing to record a statement
Moment
that I
this
will not
pleadings
press.
remains, they will have to reply on each and everything.
No. When I'm dropping these, then they will not have to.
See,
That's the-
that will be less complicated.
Less complete.
Okay, if you
Can I
withdraw the
can I have just
instant
1 minute to
PIL.
consult?
Yes, you have instructions.
Just one.
You see why dropping, then every time the state, all the parties to whom notice is issued, they will have to
Again.
answer bits and pieces of the PIL. I think it's much easier.
Better.
Because your aspect of challenging the rules also, many paragraphs dealing with that, with all the, now which
It is better
parts-
for you, madam,
of-
is what
yes.
her ladyship is.
Which pages are to be, when you issue notice, which pages are to be included and which pages are not to be
What will
included.
be
It's
replied?
going to be very complicated, the whole
Then
thing.
what I will do is one thing, I will amend this and refile with this observations. Let's that much. I will amend.
That will create difficulty for you.
No, it will not, because
Okay.
then, yeah, if your lordship permits me to drop those two prayers and then
Amend that.
amend this.
Okay, heard, Mr.
Mahmood
Mister?
Kacha,
Okay, so and so, learned counsel for the petitioner who has filed the instant PIL. The learned counsel submits that though the instant PIL filed is with regards to challenging the Andhra Pradesh, Raj Find Amendment Act, is it? Where is it?
my lords, Panchayat,
Panchayat
Panchayati Raj
Amendment Act.
Arunachal
Wait,
Pradesh
yes,
Panchayati Raj
Arunachal
Amendment
Pradesh
Act.
Panchayat
2018.
Amendment Act. Section 142,
Subsection 7.
subsection 7, submitting that this is ultra vires the Constitution of India, that is Article 243C, 243G, 243I.
Aye.
And the instance PIL is also with regards to the Dawn Constitution of the Finance Committee as per the
State Finance Commission. my
State
lords.
Finance Committee as per
State Finance Commission.
Article 243I.
47
I think it's 243I. Is it?
Yes, my lords, 243 I.
I.
Aye.
Okay, of the Constitution. And also against the utilization of the funds under the 14th and 15th Finance Commission and with regards to the routing of the funds which has not been routed through the Panchayat. Is it?
My-
Raj Panchayat.
Misappropriation of funds.
Pardon?
We say misappropriation of funds.
Misappropriation of the funds and also not routing the
Yes, yes.
funds received from the 14th and 15th Finance Commission through the
In terms of
Panchayat,
the Finance Commission's directions.
which as per the Finance Commission's direction. Having heard the submissions made by the, I'm making it very shortcut,
No, sir.
learned counsel for the petitioner, we find that the aspect of challenging the Amendment Act under Arunachal Pradesh, so and so Amendment Act, we find that these matters is not to be considered in PIL, especially considering the judgment of the Apex Court in, I think we should have a copy of the judgment.
Lords,
Please do your
if your lordship,
Let us not go to that.
Lords, I will satisfy my lords when I file it
That-
in different.
Okay,
I will try to
okay,
satisfy.
we'll leave it
Yeah.
at that. Okay, we find that these matters, which is challenging the amendment of the so and so, are not to be taken up in the instant PIL. The learned counsel for the petitioner submits that he may be allowed to file an amended PIL wherein the said challenge of the Arunachal Pradesh Panchayat so and so amendment rules will be excluded.
And the constitution of the state
And
funds.
also with regards to the constitution of the finance.
be better.
Commission.
Yes, yes, my lords, I totally agree.
Having heard the submissions made, this court finds it fit to allow the instant learned counsel for the petitioner to file an amended PIL as above by excluding those two mentions, okay? Accordingly, let's
Subject to my rights and contentions regarding the first two.
Yes. With
okay,
liberty.
subject to
With liberty.
With
giving him the liberty regarding the rights and contentions with regards to the said matters, okay? List after 3 weeks, this is the matter.
I'm deeply.
This is an appeal against the judgment and order dated 14/8/2024, convicting the appellant under section 6 of the POCSO Act, sentencing him a rigorous imprisonment for 20 years.
Yes. What are the grounds of challenge?
Ground of challenge, my lord, the age of the victim as found out as held by the learned court, my lord. She was 21 years of age, my lord, at the time of alleged incident. But just because there is an allegation that she has been subject
4 within brackets AP of 2020. Issue notice to the respondents, Mr. So-and-so, accepts notice on behalf of the respondents. Yes, any objection?
No, my lord. I leave it to your lordships, my lord.
Okay, the learned counsel for the respondent, Mr. So-and-so, submits that they will not be filing any objection in view of the above. This court find it fit. What is the reason for the delay?
That has been stated in paragraph 4, Your Lordship.
Okay, Miss So-and-so, learned counsel for the appellant submits that the reason for the delay has been explained at para 4 of the application. Okay, we have perused the reasons for delay, which has been explained at para 4 of the application. And we find it fit to condone the delay of 31 days, since no objection has also been raised by the learned counsel for the respondent. Accordingly, we condone the delay of 30 days, finding that the delay is not due to any laches or negligence on the part of the applicant. IA 185 within brackets AP of 2024 thus stands allowed and disposed of. Yes. Now, in the main rate appeal.
Lordship.
Yes. What's
This may be listed for hearing, Your Lordship. Admission.
That my learned friend satisfied for lordship that is
Yes, what
required
is
to
the
be
reason
listed
for the
the-
appeal? What is the
It was an
appeal about?
order on concession made by the learned counsel for the appellant. First of all,
What are the grounds for your appeal against the judgment? What is it about? Okay, we'll consider that in the next date or
Yes, Your
what?
Lordship, Lordship.
Because you're not prepared today.
Sorry.
they asked for tomorrow.
Oh. On the disposal of IA 185, 2024 list in the next week.
Caveat may be discharged, there is an appeal. Caveat is. Caveat in that. Caveat.
Okay, the caveat application stands discharged. Okay,
Okay.
now list in the next week.
Obliged.
That just at the time of due retirement, my lord, the verge of retirement transfer has been issued at the behest of political interference. And there's a specific provision under the guideline also that the person who is in the verge of retirement should not be transferred. And moreover, we have even division bench also, it has been confirmed that this is illegal, my lord. In that view of the matter, my lord, can this matter be listed as taken as unlisted? But already filed, my lord, today, my lord.
Not today, make it tomorrow.
My lord, only my apprehension, my lord, that since it has been done through political interference, the reliever it comes, my lord, that they will create any much further problem. That's what deeply obliged.
May I, Your Lordship? Your Lordship, I beg to mention item number 16, or 16, Your Lordship.
What happened?
We need,
It's for orders.
Yes,
What's
sure.
the matter about her?
oh yeah, we need 2 weeks' time to file our affidavit on behalf of respondent number 5, Your Lordship.
Your counter affidavit.
Yes, Your Lordship.
Okay, Mr. So, learned government advocate
Yes, Your Lordship.
for respondents number
1 to 6, Your Lordship.
1 to 6 has prayed for further time to file the counter affidavit. In view of the above list after
2 weeks, Your Lordship.
2 weeks.
Yes.
Your Lordship, there is an entry mode, it may be continued.
Meanwhile, interim order passed earlier is to continue till the next date of listing.
May please, madam. My lord, I beg to mention item number 20. Similar matter is pending before the apex court. So matter may be adjourned for
You are for the,
respondent.
who is the counsel for the petitioner? Item number 20.
We have already taken consent, Your Honor.
Heard Mr.
M. Ratan.
M. Ratan appearing on behalf of respondent number,
It's the land management, Your Honor. 2 and 3.
respondent number 2 and 3, who submits that a similar matter is pending on appeal. Is it?
In
Where?
FX court, Supreme Court.
In the apex court, and has prayed for adjournment of the matter with the consent of the petitioners. In view of the above list after 3 weeks.
3 weeks. Much obliged.
May Your Lordship, I would like to mention item number 6, 7, and 8. I'm for the respondent number 7 on behalf of father,
Hmm.
and I have taken petitioner side also.
Mention is made on behalf of Mr. O. Pada, learned counsel for respondent number,
7.
respondent number 7 for adjournment of the matter with the consent of the petitioners. In view of the above list after
3 weeks.
3 weeks.
May I please, Lordship? Lordship, I beg to mention item number 24 and 25, Lordship. And I am standing on behalf of Senior Counsel A. Kesab, Your Lordship. This matter may be adjourned today as the Senior Counsel is coming from Delhi and he will be arrived today evening only, Lordship. So he is unable to present today. So matter may be adjourned today and may be fixed tomorrow, Lordship.
Mention is made on behalf of Mr.
A. Kesab.
A.
And
Kasha,
Yes, Lordship. I have taken consent from both the counsel.
learned counsel for the, you're for the petitioner,
Yes, Lordship.
learned counsel for the petitioner for adjournment of the matter. Since the learned counsel, Mr.
A.
Kasha,
Kesab, yes.
is an outstanding counsel and will be arriving today. In view of the above, as prayed for, list
Tomorrow, Lordship.
tomorrow's date, okay, on so and so. Yes.
Obliged.
Melody. I wish to mention item number 21.
Hmm.
We like to file here one implement application.
This has been listed for hearing.
Yes,
It's in the
actually,
hearing list. So
yes,
who do you want to impede at this stage?
actually earlier there was this land acquisition matter. So earlier ninth ITVP was acquired by that land. Now the 58 is acquired that land. So we want to implement the 58 ITVP.
Then it has to be released from hearing, isn't it? Because once someone else is impleaded,
Yes.
then they will most probably want a chance to file their counter if it's required. Someone new is going to be impleaded.
No, we are going to implement them because
Huh?
they have.
So if they are impleaded, then there will be someone who's new, isn't it? A new party is going to be impleaded.
Yes.
Then most probably if someone new is impleaded, they will be wanting to file their counter. They will have to give them a chance. So this matter will have to be listed for admission. Isn't it?
Yes.
You are for the
I'm for the petitioner ESMO on behalf of
third Miss
Sonam Somu.
Sonam so and so, appearing on behalf of Mr. Esma.
Yes.
Learned Counsel for the petitioner. The Learned Counsel submits that they would like to file an impleadment application in the instant writ petition. In view of the above, this matter is to be listed under admission column and be listed after 2 weeks.
Yes.
Yes.
Much obliged.
My Lordship, I beg to mention item number 3, Your Lordship. It's a motion, in the stage of motion. Conducting counsel B pitches out of the station, Your Lordship. So I afraid this matter.
Is made on behalf of Mr. So-and-so, the Learned Counsel for the petitioner for adjournment of the matter, since the Learned Counsel for the petitioner is said to be out of station. In view of the above list,
Tomorrow, Your Lordship. It's a motion matters.
tomorrow's date.
Another, I beg to mention item number 12, Your Lordship. I'm for the respondent number 8 on behalf of J. Genie, Lordship. We've taken consent from the petitioner also. We need time to file affidavit, Your Lordship.
Okay, mention is made on behalf of Mr. So-and-so, Learned Counsel for the respondent, who submits that further time may be granted to file their counter affidavit.
Yes.
Counter affidavit. In view of the above, list after
2 weeks.
2 weeks.
My lord, I beg to mention item number 5, my lord.
Yes.
I'm for the petitioner's my lord. My lord, matter may be released after 1 week.
What's the stage? What is supposed to happen?
Admission, admission.
So have you filed your counter affidavits? Is it for admission hearing or what? What is the stage?
Admission hearing.
So we will not file our replies.
Have you filed,
No.
pleadings are complete?
No loss.
Then? So you have to file a counter affidavit.
Yes, Lordship. We need some more time here, Lordship.
Okay. Miss so-and-so, Learned Counsel for respondents number?
State respondent.
For the state respondents, okay? Has prayed for further time to file the counter affidavit. Mr. So-and-so appears on behalf of Mr.
Chorpok Modi.
Joko Modi, Learned Counsel for the petitioner. In view of the above, list the matter after 3 weeks. Yes.
Lordship. Item 22, Lordship. May I pray that this matter may be taken up day after tomorrow, Lordship. Hearing matter.
Who is the counsel for the petitioner?
I have taken consent. Become those.
It's for hearing.
Yes.
Is it after 2 weeks?
Lordship.
What's the urgency? Is there any urgency in the matter? on the,
They have that tomorrow also.
prayer made by the learned counsel. You're for the respondent, isn't
Yes,
it?
it's
Is
the
there the
respondent.
urgency in the matter? Okay, then in the, you have the list after 2 weeks. On the prayer, counsel for the petitioners, there he's not insisting on an early disposal. Okay, on the prayer made by the learned counsel for the parties, list after 2 weeks. Lots. Yes.
My lord, I beg to mention item number 4, Your Lordship.
Item number
4.
4.
Yes. Here we are supposed to file counter affidavit, so some more time may be given. What
You are
we have-
supposed to file a counter
Counter affidavit.
affidavit. You are for the respondent
Respondent.
number?
3 and 4.
Okay. A prayer is made by the learned counsel for respondent number 3 and 4 for further time to file the counter affidavit. In view of the above, list after 2 weeks.
4 weeks, Your Lordship.
Why?
4 weeks. I have been instructed to ask 4 weeks, Your Lordship.
Who is the counsel for the petitioner?
But we have already taken consent, Your Honor.
The
Deepangi.
list after 4 weeks.
Mass of us.
Yeah, Lordship. Lordship, I beg to mention item number 15. Lordship, this matter was fixed for filing of rejoinder by the petitioner. However, the petitioner.
You're for the petitioner?
Petitioner, yes,
Ah.
Lordship. So, Lordship, this, some more time may be given to file rejoinder because,
Okay, prayer is made on behalf of the learned counsel for the petitioner for further time to file the rejoinder affidavit. In view of the above, list after 2 weeks.
oblige. May it please, Lordship. Your Lordship, I'm appearing on behalf of conducting counsel, Mr. A.K. Singh, for the petitioner. I beg to mention item number 11, Your Lordship.
11.
Yes, Your Lordship.
Yes, what happened?
Yeah, he has having some health issues. The senior counsel,
Okay,
A.K. Singh.
mention is made on behalf of Mr.
A.K. Singh.
A.K. Singh, learned counsel for the petitioner for adjournment of the matter, since the learned counsel is not able to appear due to some personal difficulty. In view of the above, list after 2 weeks.
Deeply obliging.
My lord, before Lord Senior Counsel address your lordship, my lord, we have received the paragraphs coming from the department, my lord. So we may be allowed to file our affidavit, my lord. We will file within 4 weeks, my lord. We have just received the comments, my lord.
Okay. Mr. So-and-so. Learned, I think additional AG for the state respondents
Yes.
has prayed for further time to file the counter affidavit. In view of the above, list after,
4 weeks, my lord.
yes, we listed after 4 weeks for the state respondents to file the counter affidavit.
Deeply obliged.
My lord, this is a tender matter. So here the main issue is the petitioner has participated the tender and in the tender, his tender bid has been rejected only on the ground that the work experience, the executive engineer and superintendent of engineer has not put the signature. And their contention, the petitioner condition is that for the contractor of class 4 and 5, work experience is not required as per the Arunachal Pradesh District-Based Entrepreneurship and Professional Initiative Development and Promotion Act 2015. This is the main thing. And moreover, we have sought for the grounds of rejection. This was verbally informed, and it was ground sought, and they have not given in written also. Whereas the board member has to show the reason for the rejection. And on this reason, we have applied RPA, and application also has been made, which is not annexed in this annexure in this petition. That
as it was made after the filing of application was made after the filing of this petition. It was filed before the vacation. So status report, if only the status report comes, whether the ground by showing the grounds of rejection, then petitioner will be satisfied. If they have in fact rejected the petitioner's tender bid on the basis of any rules or guidelines.
So this is challenging the tender process, is it?
Challenging the tender process.
By the board members in this NIT dated 24 June,
Yes, 24 June.
when you were not selected or what?
My tender bid has been rejected. My tender bid has been
For
rejected.
rejection of
And that
your
they have not,
tender.
they not assign any reason for rejection. Whereas they ought to have. And they have verbally informed that your work experience has not, has the approval or signature of chief engineer or superintendent of engineer. Whereas as per the rules, as per tender guidelines, it says that the class 4 and class 5 contractor, there is no requirement of any work experience also.
Where's that?
My lord, please come to page number 17, my lord.
17.
17. This is the rules of Arunachal Pradesh district-based entrepreneurial and professional incentive development professional act 2015, made particular for each and every districts. So here the rules says, rules page number 7 under column number 2C. Here it says the contractors who has been awarded the work called tender shall not be let.
This is subletting his work. This is different.
This is the number C, my lord.
C.
D, my lord. D.
Okay.
The category class 4 and 5 contractor shall be exempted from the requirement of the producing proof of completion of works, a similar type of works last for 5 years, quality of participation in the tender. So they are, because they are initial contractors, so they class 4 and class 5 are not required for the tender experience certificate. In case if it is amount is, because amount is also limited for the class 4 and class 5. So this is the basic grievances that the petitioner has. And only if the status report comes that under which grounds they have been rejected, that will suffice. If they have any other grounds, then petitioner will have nothing to submit more. Or if they have rejected
So
without
the
any,
grounds of rejection has not been properly mentioned or what?
they have not, we have written applications that has been not responded yet.
Where's the application?
Application is not enclosed, but separately I can.
Should it close the applications, then
No,
we
my-
can dispose of the instant writ petition for considering your application, then we can dispose of this writ petition.
Yes, my lord. That could have done, but I have submitted application after filing this petition. That was before the vacation.
See, if you want, you have made a representation,
Yes,
okay? And you're saying that your representation has not been considered. And no response to your representation, isn't
Yes.
it? Then if there's a representation that is pending for consideration, then the instant writ petition can be disposed of at the initial stage, at the stage of motion itself, by passing an order to the respondents to consider and reply to your representation within a certain period. Okay, and if you are still unhappy with the reply to your representation, then maybe you can have a case. Right now, your representation is still pending. But now in this writ petition, a copy of the representation is not here.
is not here, but
It's not here.
I have available with me the copy of the repetition.
That it should be, if you're going to dispose of the instant writ petition based on that representation, then the copy of the representation should be enclosed.
My lord, may kindly peruse. This is after the filing.
But then in your prayer, have you mentioned anything about your representation in your writ petition?
Only
In your
the-
writ petition, have you mentioned anything about the representation here?
No, only the ground,
Nothing. Then how can we dispose it off on those grounds?
only the
But
grounds of rejection.
facts of the case is that your representation is still pending, and this is dated 04/10/2024,
Mm.
isn't it?
Mm.
So this representation has to be first disposed of. And then we'll see whether if you're unhappy with your, what is their representation about? Let's see the last, the operative part.
One is for punishing of the rejection ground, and another is for the cancellation of the process of the NIT, which is not made against the guidelines and rules provided under the NIT.
But since this has not been included in your.
Yes, my lord,
writ
that is
petition, what do we
admittedly,
do?
honestly.
So what do we do? You withdraw, file afresh, and then we can dispose it. in
Yeah,
the
that
next
also,
meeting?
that also.
That's a shortcut.
Yes,
And then you'll have
shorter,
to
shorter, my lord,
apologize.
but liberty to file a
Yes.
press,
Heard
that's
this
far
now.
better, my lord.
So and so, learned counsel for the petitioner, who has prayed that he may be allowed to withdraw the instant writ petition with a permission to file afresh. Accordingly, the instant writ petition number 457 within brackets AP of 2024 is allowed to be withdrawn with a permission to file.
Liberty to file a press.
With the liberty to file afresh if so advised. In view of the above, the instant writ petition so and so stands disposed of as above. On withdrawal as above, yes. Yes.
Possibly.
May your lordship. Lordship. Here, your lordship, I'm challenging the impugn order passed by the disciplinary authority, your lordship, wherein the service increment has been deducted with cumulative effect. Your lordship, the case of the petitioner in nutshell is that on 17/12/2021, your lordship,
Yes.
memorandum containing article of charges was served to the petitioner, your lordship.
Now
Yeah.
wait, before you continue, in
Lordship.
the last court date, the matter was heard at length, is it?
Lordship.
On
On
19/7, it was heard at length.
No, your lordship, on 23/7/2024, matter was adjourned, your lordship.
And then
For hearing.
on 19/7, it was heard for some time, is it?
Lordship, lordship.
And then on 23rd, it was adjourned. Yes, so we'll have to hear it again. Yes.
Your lordship, here, your lordship, the article of charges was served upon the petitioner, your lordship. Thereafter, your lordship, charges drawn against the petitioner was that the petitioner had illicit relationship with a complainant, your lordship.
Okay.
The charges which was drawn, your lordship.
Uh,
Accordingly, inquiry officer was appointed for departmental proceedings, inquiry, and EO submitted a report holding that the charges of illicit relationship has been proved. Thereafter, your lordship, inquiry report was furnished to me, and petitioner has submitted his representations denying the charges that he had cheated and denied financial support, your lordship. Your lordship, thereafter, your lordship, the disciplinary authority by order dated 19/7/2022, disciplinary authority accepted the findings of EO, inquiry officer, and thereafter imposed penalty of withholding service increment for service increment with cumulative effect, your lordship. Then being agreed, your lordship, petitioner filed his representation statutory appeal, your lordship, and that was dismissed. Thereafter again, your lordship, he filed revision, and that was also dismissed. And therefore, the petitioner is before your lordship. Your lordship, the order is in page number 39, your lordship. Impugn order.
Page number 39.
Page number 39, annexure 4.
Yes.
Your lordship, the relevant portion, your lordship. Paragraph number, last second para, your lordship. It says, therefore, in exercise of power conferred under sub-rule 2G of Rule 3 of Arunachal Pradesh Police Discipline and Appeal Rule 1999, Amendment Rules, do hereby award a penalty of withholding of 4 service increment with cumulative effect, with effect from 1/1/2022, Your Lordship. So this is an impugn order, Your Lordship, wherein the service increment has been withheld. Here, my Lordship, my limited prayer is that the authorities ought to have considered that I'm maintaining a family also, Your Lordship.
So you're not denying?
I'm not denying, Your Lordship.
Okay, so
I'm
the
not de-
findings of the disciplinary authorities is correct, you were having an illicit affair.
Yes, Your Lordship.
Okay.
The findings of the inquiry officer was that I was not supporting the complainant during her pregnancy. No financial support was given to the complainant. That was the report, Your Lordship. Now, as per the
Wait, come back to the facts of the case.
Your Lordship.
Not to indulge in such immoral activities in future. Okay, because of your illicit activities, you are having a child with someone else.
Yes, I have begotten a child from this relationship.
Okay.
I have first wife, and this is she.
Okay, this is outside marriage.
Yes,
Now
Your
you
Lordship.
have an illegitimate child.
Yes, Your Lordship.
So the disciplinary authority charged you for not supporting the illicit,
The complainant and her child.
Okay.
No financial support was given. That was the
So
allegation.
did she approach the court for maintenance?
Yes,
under
exactly, Your
125?
Lordship. She
CRPC?
approached. Yes,
Okay. So come
maintain-
to the facts of the case.
Yes, Your Lordship.
Uh-huh.
Thereafter, the complainant also filed maintenance application that is already been disposed of. I'm already maintaining the complainant.
Okay.
I'm paying the maintenance amount.
Maintenance amount
Yes,
is
Your
being
Lordship.
paid.
Yes,
Then-
Your Lordship. And if she has,
But it's becoming of a what? An officer to have an illicit affair. Is that the main charge?
yes, only as per the order.
Let's see the order. What is the operative part? What are you guilty of? Because you're maintaining also.
In the entire order, it has been, I have been charged, I have been alleged that my conduct of having illicit affairs, illicit relationship.
Okay, not for non-maintenance,
No,
but
no.
for having an illicit
Illicit affairs,
Okay.
Lordship. That was the charge,
Mm-hmm.
that I have illicit relationship with so and so.
Okay.
So,
Which is unbecoming of an
Yes,
officer.
yes, Your
Okay,
Lordship.
outside marriage. So you are convicted. So your main point is that the punishment which has been imposed upon you, it is under what? Under sub-rule 2G of
2G.
Rule 3.
Yes, Your Lordship.
Let's read what are the steps that can be taken. This is major penalty or minor?
It comes under major penalty, Your Lordship.
Okay.
It is a major penalty with cumulative effect, Your Lordship. So my humble prayer is that the award, whatever award that has been imposed upon me, is disproportionate, because, Your Lordship, the authorities ought to have considered that I'm maintaining the family, both the parties, my wife and then her, the complainant, and my family, my own family, my children, and that has not been taken into consideration while passing this penalty, Your Lordship.
Okay, now this impugned order, it is passed by whom?
It is passed by respondent number 4, commandant, respondent number 4, disciplinary.
Commandant is the disciplinary
Yes, Your
authority.
Lordship.
Then you had gone on appeal, isn't
Yes,
it?
I have gone to appeal and my appeal was dismissed.
The
Your Lordship.
appellate authority, what is their reasoning? Where's the order of the appellate authority?
That is in page number, Your Lordship, page number 46,
46.
Lordship.
They
Annexure
didn't
6.
consider your appeal on what grounds? Let's see. What did they say?
That's operative portion is in page number 47. Page
So
num-
what is the reasoning made by them? The
That,
appellate authority?
It says, Your Lordship, I have gone through the appeal filed by the Head Constable Tapu Ali Ijing and produced DE report and evidence relied on by the EO during inquiry. The charge that Head Constable Tapu Ali Ijing was having illicit relation with Srimati Tilek Taram and produced a fake divorce paper of his earlier marriage is proved in inquiry. It has been adequately punished for his proved misconduct. I find no reason to interfere with the decision taken by the disciplinary authority. This is the findings, Your Lordship. Thereafter, petitioner had filed a revision application and revisionist authority has upheld the order of the appellate authority, Your Lordship.
So your conduct, according to them, deserves major penalty.
Lordship.
While you're saying that it's not serious, so it should be made lesser.
My prayer is that, Your Lordship, the whatever award of penalty has been imposed upon me is not proportionate, Your Lordship, because the authorities ought to have at least considered that I have paying the maintenance amount to both the parties. I have maintaining my own family.
How much are you paying? every
Your
month?
Lordship, that also I have annexed. Page number 55, Your Lordship.
25.
Type copy. 55.
55.
Lordship. Before that, Your Lordship, yes, Your Lordship. Serial number 1 to 3, column number 3, Srimati Tilektaram, 10,000. And Srimati Nyam Tatung Ijing, 15,000.
Who are there?
Nyam Tatung Ijing is my first wife, Your Lordship. She is my first wife.
The first wife? Okay, so you have divorced your first wife also?
No, we are
So
not
you're
staying.
paying maintenance to her also?
Yes,
is
Your
it?
Lordship. Yes, Your Lordship.
You're paying maintenance to your first wife
Lordship.
and also to the person with whom you were having illicit
Yes, Your Lordship.
relationship.
Yes, Your Lordship.
So is he not married to his first wife? Why is he paying maintenance? He's paying maintenance to his first wife.
Lordship.
1,000, 1,500.
15,000.
Okay, 15,000,
Lordship.
yes. So why is he paying maintenance to his first wife when he's married to her as it is? Is this a maintenance amount?
Yes, Your Lordship. This is the maintenance amount.
So
passed by
he's
the-
divorced his first wife also?
No, no. We are not, legally, we are not divorced because as per.
But you're staying separately, so
We
he
are
has to
staying
pay
separately.
maintenance.
We are staying separately, so she has filed a maintenance applications, and as per the order of the Honorable Court, I'm paying maintenance amount to her. And to Srimati
So does he have
Tilektaram,
a third wife? No.
Lordship?
So does he have a third wife, someone who he's living with right now?
No, Your Lordship.
He's
So she-
separated from his first wife, so he's paying maintenance to her. And then he has another person with whom he has an illicit relationship, and he's also paying maintenance for her. Is it?
Yes, Your Lordship.
So monthly deduction is
25,000 a month.
What is his pay income?
His salary, total salary
Salary?
is, Your Lordship,
Your ground is
Your
that
Lordship,
it
in
is
my
too harsh.
paragraph number 17, I have stated,
17.
Your Lordship,
Page?
page number 11, para 17 of my petition. Here I have mentioned the gross salary, Your Lordship. May I, Your Lordship?
Yes.
That the petitioner begged to state that after deduction of for service increment, his pay and allowances, the petitioner is getting gross pay of rupees 70,000 and net pay is rupees 37,000. It is also pertinent to state that an amount of 25,000 being monthly maintenance amount to Srimati Tilektaram and Nyayum Tatung is being deducted. After all the said deduction, the petitioner's monthly salary comes to an amount of rupees 12,760 only, and out of which he has to maintain himself and his old-aged parents. The action of the authorities against the welfare scheme, Your Lordship. So,
Okay.
so Your Lordship, the impugn order which has passed by the respondent number 4 is liable to be quashed and set aside, Your Lordship. And before that, Your Lordship, the entire order of the inquiry report as well as the disciplinary authority which the order has been passed and the appellate order of the appellate authority, except it is clear that the order, except saying that petitioner had illicit relationship, no reason forthcoming that his conduct has any nexus with the duty performed by the petitioner, Your Lordship. No any interference has been done with honest discharge of his duty, Your Lordship. So your lordship, even last occasion also, your lordship, I have placed one judgment, your lordship.
Judgment, let's see.
And more so, your lordship, before that, in our customary traditions, two wife is permissible, your lordship.
Is it?
Yes, your lordship.
Even government has made it permissible.
Pardon?
Two wives.
Where, see, you have your customary laws with you? Does it mention anyway? Do you have a copy of your customary laws? So you're going to say that this is actually not a conduct which is unbecoming because two wives are quite common here, is it? So give me a customary law, something to show that it is not something out
your
of.
lordship.
Right now, I don't have, but it is there.
What about the respondents?
Be able to tell the truth.
But something is, have something written that they are, is it there in writing?
It is
In
there.
their customary law?
It is there.
Of, but it must be a certain tribe.
CRPC will be.
It must be belonging to a certain tribe.
My lord,
Is
in
it?
fact, it's a customary practice,
Huh.
but there is nothing in written,
Right, written.
written saying that we can have more than one wife, my lord. But legally, it is, there is nothing written that, because we don't have a written customary practice, my lord. However, the CCA rules provides, even for the state government employees, provides that even in, if your customary practice,
You cannot have more than two wives. No?
you can take prior permission from the government. You can take permission from the government, but just because the customary practice allows you to have more than one wife, my lord, you cannot get married, my lord. You have to take an approval from the government.
Because that's bigamy. It's an offense under IPC.
Yes, your lordship. I agree, your lordship. Here also, the conduct of the petitioner amounts to adultery, your lordship. This cannot be initiation of any disciplinary proceedings, your lordship. It amounts to adultery. So anyway, your lordship.
Anyway, so your judgment, let's see the operation.
Here also
part.
the allegations, no, your lordship, allegation against the petitioner was that he had an illicit relationship. While allowing these writ petitions,
This is Rajasthan.
Rajasthan High Court, your lordship. While allowing these writ petitions, the court observed that an act of relationship entered by an individual with another male or female, with his or her spouse being alive, would be amounting to adultery and would be considered as immoral act. The relevant para is paragraph number 43, 44, 45.
Okay, this is something a little bit unusual.
Lordship.
Yes. 43, okay.
43,
So what was the final decision of the court?
Your lordship. 44, 43, 44, 45, your lordship.
So read the relevant portion.
Okay, your lordship. Para 43. Thus, this court feels that human dignity attaches to itself also a right concept of autonomy and also a right to take one's own decisions for himself or herself relating to his or her body and choice of his or her partner for whom he or she wishes to live or have sexual intercourse. These choices and selection cannot be subject matter of departmental proceedings, and no employer can be allowed to do moral policing on its employee which go beyond the domain of his public life. 44. In view of the above discussions, the observations, this court is of the opinion that an act of the relationship entered by an individual with another female or male as the case may be, while his or her spouse is alive, would be an act of amounting to adultery and would be considered as an immoral act. As far as the Indian society is concerned, it is not to be appreciated. The same would, however, not be a ground for initiating departmental proceedings by the employer. And it be left best for the persons who may be affected individually to take a remedy and proceed against him, her in civil law or for initiating divorce proceeding, as the case may be. 45. Thus, this court concludes that the respondent had no authority to issue a letter directing the petitioner to undergo DNA test along with the child or
Okay, so here the issue is different. It's not concerning disciplinary authority, it's concerning the child, is it? Whether
Yeah.
it is his child or.
the facts of the case, Your Lordship. Here also the
Read 46.
46. Consequently, both the writ petitions are allowed with all consequential benefits, and it is held that the petitioner Mahesh Chand Sharma, who has attended superannuations during pendency of writ petitions, shall be entitled to all retirement and post-retirement benefits, and similarly, the petition Dharma Rani shall also be
So
entitled.
his benefits were withheld in this case?
Yes, Your Lordship. Lordship. Here, the illicit relationship is amounting to adultery. It cannot be, the conduct cannot be for initiation of any disciplinary proceedings.
So you're saying that his duty has not been affected?
Yes, Your Lordship.
And that he's paying maintenance anyways? under
Yes,
125.
anyways, I'm paying maintenance, and already maintenance amount has been paid monthly. It has been deducted, straightway deducted from my salary, Your Lordship. Therefore, my humble prayer is that, Your Lordship, whatever the punishment which has been awarded is liable to be set aside, Your Lordship.
Okay, wait, the disciplinary proceedings were initiated under what, this thing? What provisions of the rules or judge, the articles, whatever, where is it? For violation of what? He was found guilty of which provisions of the?
That specific, no, any specific provision has been mentioned while awarding the punishment, Your Lordship. In the entire order, it only says illicit relations. He had illicit relations with the complainant. And the complainant, my first wife is not the complainant here, Your Lordship. The complainant is.
Let's see the, wait, this is the petition. So where is the? Page 20.
Page
Article of charge
Your
is
Lordship.
annexure 1.
Lordship, page 20.
Each article of, let's see the article 1.
Next page, page number 21, Your Lordship. Annexure 1, article 1, Your Lordship. Page number 21. That head constable Tapo Ali Ijing of Youth IRBN of Epkoi Chimpu had been illicit relationship with Srimati Tilek Taram, complainant, since October 2020, with a promise to marry Srimati Tilek Taram by producing divorce paper of earlier marriage, and both of them were tied in a knot of wedding on 30th October. During the month of May 2021, Srimati Tilek Taram got conceived, and both head constable Tapo Ali Ijing and Srimati Tilek Taram decided to give birth to the unborn baby. From the month of July 2021 onwards, head constable Tapo Ali Ijing and Srimati Tilek Taram could not meet or contact each other, as head constable HC Tapo Ali Ijing was engaged in extramarital affairs. Moreover, head constable Tapo Ali Ijing intentionally avoided to sharing the physical and the financial problems of Srimati Tilek Taram at the hours of need, and head constable Tapo Ali Ijing cheated Srimati Tilek Taram in a wrongful manner. Hence, he cheated his wife as well as Srimati Tilek Taram by making false promise of marriage. Based on her complaint, he is not providing her with any moral, physical, or financial support during her pregnancy.
So based on her complaint, he is not providing her with any moral, physical, or financial support during her pregnancy. Now, is this correct?
This is the report of the inquiry officer, which I have, pursuant to this inquiry report, which was published today, I have filed
to it.
Yes, Your Lordship.
Saying that you are giving her maintenance.
Yes, Your Lordship. I have clarified, Your Lordship.
Okay.
And that has not been taken into considerations by the authority, Your Lordship.
So the main thing is that he's not, okay. Then
Exactly.
the next one, then the second article of charges.
It's altogether same again, Your Lordship. Whereas complainant reports.
So the second one is Oh, it's the same.
Same. In the entire order, it only says about the illicit relationship, Your Lordship, and that I have begotten a child, and I have not maintained. Financially, I have not supported.
Okay. I've got your point, huh?
Lordship.
So respondents, what do you have to say? Have you filed your
Yes,
counter?
yes, my lord. Yes, my lord. My lord, disciplinary proceedings are initiated for misconduct, my lord. Misconduct here, my lord, at page 20, imputation of misconduct. Misconduct is not for, although there is a word illicit affairs, relationship, but what is the misconduct is that he
The
has,
performance of his duty.
no, my lord, it is not, misconduct will not be only with regard to the performance of duty.
Okay.
Misconduct means any moral misconduct also, my lord. Now here, although there is a word illicit relationship with some other, but the main complaint, if the article of charge is that there is a false promise of marriage to the complainant, showing a fake divorce paper of his earlier marriage. That false promise is actually, if had there been a criminal complaint, criminal FIR, he would have had a different consequences.
It depends, huh?
Yes, madam. And to fortify that he has had an affair with this complainant, there is already a child born, which he does not
He doesn't deny that.
deny that. So now that is itself the conduct of making a false promise and begotten a child, showing a fake divorce paper itself is a misconduct, my lord. That should not have been done by a government servant. That too enough police officer force.
Okay, I'll
Now-
just break you here. Your Article 1, the first charge is Article 1,
Yes.
isn't it? Now, Article 1, if you read the last
Yes,
part
of
the
course.
para, it is that he's not providing her with moral, physical, or financial
Yes,
support
that is
during her
consequential.
presence.
Yes, consequential. After false promise of marriage, these are the consequences. Had he made a false promise and thereafter had he provided this financial, this maybe the complainant would not have made the complaint. After giving a false promise, making her give birth to a baby, and thereafter abandoning her, that has led. But the
Okay, fine. So
now,
what
my
about
lord,
the
I
false
will.
promise of marriage?
Yes, madam. I will also not go that much, since what I have also seen that now he is maintaining the child,
He's giving maintenance
maintenance
now.
to the child, as well as the earlier maintenance to this second wife, so-called complainant, and earlier wife, madam. Now there is no infirmity in the impugn orders, but however, if my lord finds that despite giving maintenance to both this complainant and the earlier wife, and then again deducting his increments, that will be to hers. I will leave it up to your lordship. But the merit of the impugn order, the findings cannot be disputed.
No, he does not deny. Okay,
That
but
is
the
not
only
denied.
point is I'm already maintaining her.
Yes, that aspect can be looked into, my lord.
So I think we can make some
And
changes.
that with regard to illicit affairs, that relationship, that judgment is because of the first wife giving a complaint against the husband for having a illicit affairs. Here, the actual facts is that false promise of marriage. This is not a case of illicit affairs, adultery. This complainant is not married to someone else. Adultery is that you are having an illicit affairs with someone's wife, my lord.
I got it. Now, only thing is, what about the false promise of
Yes,
marriage?
my lord. that
Was any statements taken, evidence taken? What does he say concerning false marriage? I mean, whatever he
what
has been made against him, what was his defense?
his defense
Did he
is,
make, did he admit that he made any false promise of marriage?
my lord, if at
Who
page
were
29,
examined as witnesses?
my lord, at page 29, it is the
29.
inquiry, yes, inquiry
Huh.
report. The
Yes,
from
29.
serial number 4, my lord, statement of the charge official, my lord.
Yes.
On being examined, HCA Tapo Eli Singh, so and so, stated that he refused to accept the charge framed against him in Article 1, that he had cheated so and so, denied the financial support during her pregnancy. That, sir, he and Srimati Telegram were friends on Facebook in the app initio and used to talk on in Facebook Messenger only. And after sharing their contract number, they had continued to talk on regular basis since the month of September 2020. On 30th October 2020, they finally met for the first time at rowing and made physical relationship with each other. On 26 November 2020, Srimati so-and-so came to Naharlagan and met him for the second time, but he would like to mention that before they met their physical relationship, he never hid about his marriage and have 2 children and a daughter, but he never produced any marriage divorce paper. In the first and second meet with Srimati Tilak so-and-so. After their 2 months of relationship, his wife so-and-so also talked to her on phone in the month of December 2020 and shared the details that Mr. So-and-so was married to her. But after coming to know about the details, she never gave up the related and repeatedly invited him to come to rowing so-and-so. On the day in the evening hours, she asked him to provide marriage divorce paper. To fulfill her demand, he made a duplicate divorce paper since she warned him that if he had failed to provide that document, she will commit suicide, and he did not save her life, madam. This is the explanation, but the fact remains that he produced. After prolonged relationship, she got conceived in so-and-so. He did not have any malicious intention, but he really wanted to marry her and make his legal wife. But after being conceived for 3 months, she herself invited intolerable circumstances by making her ex-boyfriend in presence and sometimes making video calls in abnormal time. So-and-so, madam. In any case, my lord, these are allegations, counter allegations, but there was a document produced.
Anyway, yes.
Now the issue here, whether there is a child born.
Give me some authorities whether this type of personal relationship, okay, of a government official is to be considered as a misconduct under the whatever disciplinary rules that you have.
My lord, the conduct which may amount to even a criminal this offense, my lord.
Criminal law offense under what section?
My lord, here criminal
Promise to marry. This is not
yes,
under the promise of marriage. Huh?
false promise of marriage.
420 or what? What? Under
No,
what section will it come?
420 cheating, 417, my lord, or even 376, my lord, elsewhere 376, my lord. This was with a consent because the imputation is that he did not disclose that he was married, and he sought a divorce, false divorce paper.
Okay, what? Okay, so supposing the punishment imposed upon him is too harsh, what would be a minor this thing? Let's come to some consensus and discuss.
Yes, my lord, my
Any
lord.
suggestion, counsel for the petitioner? It should be at least reduced to something. Anything? What are the this thing?
Already the penalty of
Penalty, any minor
it was
penalty?
with effect from 1/1/2023, Your Lordship.
Hmm.
And now already 1 year has been passed.
1/1/2023.
Lordship, with
Ah.
effect from.
So
So now my prayer would be, Your Lordship,
how do we dispose of this matter, Give me some idea. Simple matter.
Lordship.
Yes, yes.
Since I am giving the maintenance to both my wife and the complainant, and I have old age parents to maintain as well, and the children from my first marriage as well as from the second. So, Your Lordship, the order of
The penalty or punishment imposed upon him is harsh.
harsh, Your Lordship,
Okay.
and that also with cumulative effect.
So supposing we make it has already awarding the penalty of withholding for service
For service.
increments
Lordship,
with effect from 2023.
1/1/2023.
1/1. So if it is
It's already going to be 2 years.
2 years,
Lordship.
so 2 increments have been withheld.
Lordship,
So we can reduce it to 2 increments without
cumulative effect.
cumulative effect.
Lordship,
It's harsh, so we'll alter this
Lordship.
because we shouldn't encourage men having relationships when
Exactly,
they're
yeah.
young. Okay, because I think at the time in their service rules also, there's a provision that he's not having any, he's not married and no to marriages or something.
Yes,
That
yes,
thing
yes.
is there in your service, this thing also at the time when you're going to join, isn't it?
Lordship.
So I'll pass the order later. Okay, we'll allow the writ petition to the extent that it will be reduced to 2 service increments without cumulative effect.
Lordship.
Yes, my lord,
What do
and
we
that,
dispose of?
because the maintenance.
Maintenance will continue.
Will continue,
maintenance
my
will
lord, that
continue.
observation.
That's
to-
different.
Yes.
I'm
That's
ready to
the-
maintain
no,
the law.
125 is different. That
Yes,
will
yes,
not
that-
interfere with. This is only the disciplinary proceedings. I'll pass the order later.
Yes.
Okay,
Great.
disposed of.
Lordship, obliged.
Yes. That's all. Anything?
May I, my lord? This is pension matter, my lord. Affidavit.
Yes.
This is pension matter, my lord. Affidavit yet to file by the respondent number 1, man. Respondent number 2 already file their affidavit, my lord. But respondent number 1 yet to file.
Respondent number 1 is the government. 2. Who is respondent number 1? 1 and 2 is the government?
No, 2 is also government. 1 is competent authority, my lord. The power, Department of Power.
So who is appearing for respondent number 1?
Respondent.
Respondent number 1 has to file the counter, is it?
Yes, ma'am.
Respondent number 2, you have filed?
Yes.
Okay, yes. Mr. So-and-so, learned counsel for the petitioner is present. Full stop, okay. Then, Mr.
Lordship, I'm on behalf of L Permit, Standing Counsel Power Department.
Mr. So-and-so appears on behalf of Mr. L. Permit, standing counsel for respondent number 1. Is it? The learned counsel has prayed for further time to file their counter affidavit, while Miss So-and-so, learned government advocate for respondent number 2, submits that they have already filed their counter affidavit. In view of the above, list after how long?
3
will it
weeks,
take?
Lordship.
3 weeks for respondent number 1 to file their counter affidavit. Yes.
Thank you, Lordship.
Lordship, my lord, as for the order, my lord, the amendment petition has been, course has been done, my lord. Respondent 4 and 5, page 7A in the amendment of the course title.
Okay, you have this thing. You have made an amendment to your cost title?
Yes, ma'am.
Okay.
So, my lord, in that view, my lord, it needs a step to be served to the newly.
Included
Included,
respondent
yes.
Notice is to be
Yes,
served.
yes.
Notice has to be
Yes.
issued again.
Heard Mr.
T-zone.
T-Zone, learned counsel for the petitioner, who submits that he has filed the amended post title
Yes, ma'am.
in terms of on the disposal of the IA, is it? IA within brackets C 12 within brackets AP 2024. In view of the above, this court finds that the learned counsel for the petitioner is to issue notice to the newly included respondent number 5 through
4 and 5.
4 and 5.
4 and 5.
Newly included respondents number 4 and 5 through registered post with AD within 3 days, returnable by 3 weeks. List after 3 weeks.
Item number 14.
Your Lordship, I'm appearing on behalf of the petitioners. Your Lordship, in this case, the respondents are yet to file their reply.
Your Lordship, we have not been furnished with extra copies till date, Your Lordship. Despite the order dated 14/11/23, Your Lordship, they have not furnished us the extra copies till date, Your Lordship. Which is why we are.
Copies of the petition.
Yes, Your Lordship. I am for respondent number 2, Your Lordship.
Okay, Mr. So-and-so learned counsel for, you're the government advocate.
Yes, Your Lordship.
For respondent number
2, Your Lordship.
2, submits that copy of the instant writ petition has not been furnished to them. In view of the above, Miss
M. Gogoi.
M. Gogoi, is it?
Yes.
Your name?
Yes,
Miss
Your
M.
Lordship.
Gogoi, appearing
Yes,
on behalf of Mr.
Petitioners.
Mr.
Put the petition.
Appearing
CW
on
Mantau.
behalf of Mr.
No, she is also the
Advocate
counsel of
CW
petitioner,
Mantau.
Your Lordship. Her name is there in the cause list, Your Lordship. M. Gogoi.
Okay, while Ms. M. Gogoi, learned counsel for the petitioner, appears through VC. And full stop. The learned counsel for the petitioner is to furnish requisite copies of the writ petition to the learned counsel for the respondent number 2. In view of the above, list after 2 weeks.
Your
Yes,
Lordship,
Your
interim is there, Your Lordship.
Meanwhile, interim order passed earlier
Because of
is
the
to
interim.
continue till the next returnable date. There is an interim order?
Yes, Your Lordship.
Yes. So you are supposed to furnish a copy of the writ petition to the learned counsel of for respondent number 2.
Yes, Your Lordship.
Why have you not filed a copy, furnished a copy till date?
We have furnished, Your Lordship,
This
in
is
advertise.
the matter was first listed on for motion on 23rd 08 2023. Is
Yes,
it?
Your Lordship. More than a year, Your Lordship.
So it's, yes, it's almost more than a year and a copy has not been furnished to respondent
And Your
number, so
Lordship,
that is the government, is it?
White order is the 14/11/23, Your Lordship. Your Lordship has directed them to furnish us with the extra copies, Your Lordship. But till date, they have not furnished us with,
Ah.
which is why we are unable to get the parawise comment, Your Lordship.
So
We'll take
till
fresh
date,
steps. Yes.
you have to take steps to furnish requisite copies of the writ petition to the respondents, all the respondents. So now
Yeah.
only respondent number 2 is represented today, the state government. Okay, so to
Yes.
the government advocate, you have to give a copy of the writ petition,
Yes.
isn't it? So list after 2 weeks. Okay.
Congratulations.
My lord. Please, Your Lordship. Lordship, I'm sorry, my lord, this morning I supposed to mention this item, but my lord,
Okay.
so my lord, may I pray the matter may be listed after 4 weeks. In the meantime, my lord, we are under negotiation. So there is likelihood of settlement of the issues between the, my lord, the petitioner and the
Okay.
department.
I heard Mr. M. Kato. Is it learned counsel for the petitioner along with Mr.
El Perme, my lord.
L. Permit, learned standing counsel. Is
My
it
lord.
Yes, ma'am.
for the bar department.
Bar
also. The learned counsels for both the parties submit that the parties are attempting to come to an amicable settlement outside court and has prayed for adjournment.
My lord.
In view of the above, list after
4 weeks, ma'am.
4 weeks.
Much obliged.
My lord, respondent number 6 and 7 is private respondent. They have filed their affidavit in opposition. And respondent number 1 to 5, who is Department of Health government, has not filed
Oh,
yet to file the affidavit.
so respondents have to file the counter affidavit.
My lord, just further 2 weeks time may be granted, my lord.
Anyway, Mr. So-and-so, learned counsel for the petitioner is present along with Mr.
T. Tagam for the standing council, health department.
Okay, T. Tagat, learned standing counsel for health department and Mr.
I'm private respondent, respondent number 6 and 7.
Mr. So-and-so, learned counsel for private respondents number 6 and 7. The learned counsels, new para, okay, for the respondents. Is it have prayed for further time? Have you filed?
Yeah, I have filed. We have
Okay.
filed.
The learned standing counsel for the Health and Family Department has prayed for further 2 weeks' time. Is it to file the counter affidavit? In view of the above, list after 2 weeks.
My lord, there is interim order that may continue.
Meanwhile, interim order passed earlier shall continue till the next date of listing. Yes.
Obliged.
Yes, office note says affidavit in opposition is not filed by respondents number 5 and 6, 5 to 8. Is it? Who
Yes,
is
ma'am.
it?
I'm for the respondent number 5, 6, 7, 8.
Oh, what happened?
We are yet to file an affidavit in opposition.
Yes, we know.
We need
So when
some
are
more
you going
time.
to file?
We need some more time.
How much time?
2 weeks may be granted.
Yes, Mr.
BBI.
P. So-and-so, learned counsel for respondent number 5 to 8.
Yes.
Has prayed for further time to file the counter affidavit. In view of the above, list after 2 weeks.
Yes.
Anything else to mention? I don't think we have.
Interim, my lord, is dated.
Meanwhile, as prayed for by the learned counsel for the petitioner, interim order passed earlier shall continue till the next date of listing.
Yes,
You can mention the name of the counsel for the petitioner.
May I please, Your Lordship?
Yes.
Your Lordship, I pray for the disposal of this writ petitioning, Your Lordship. This is a petition whereby the petitioner is seeking for the alteration of his date of birth in the service record in terms of the notification issued by the government of India. Your Lordship, may I take you to the page number 34? Page number 34 of the writ petition, annexure 1.
34, yes.
Uh,
What is this notification? Oh.
This is a notification whereby the government employees are given permission to make necessary correction in date of
Date of birth.
birth. May I read
Okay,
you
yes.
this notification? The type could be page number 36, Your Lordship. In exercise of the power conferred by the provision to Article 309 and Clause 5 of the Article 148 of the Constitution, and in consultation with the Comptroller and Auditor General of India, so far as person serving in the Indian Audit and Account Department are concerned, The President hereby makes the following rules further to amend and fundamental rules. Namely, these rules may be called the Fundamental Fourth Amendment Rule 1979. They shall come into force from the date of their publication in the official gazette. For the existing note 5 below, Rule 56, the polling notes shall be substituted. Namely, Your Lordship, the date on which a government servant attained the age of 58 years or 60 years, as the case may be, shall be determined with reference to the date of birth declared by the government servant at the time of appointment and accepted by the appropriate authority on production, as far as possible, of confirmatory documents such as high school or higher secondary or secondary certificate or extract from birth register. The date of birth should declared by the government servant and accepted by the appropriate authority shall not be subject to any alteration except as specified in this note. An alteration of date of birth of a government servant can be made with the sanction of the Ministry or Department of the Central Government or the Controller and Audit and Account Department or an administrator of a union territory under which the government servant is, if there are three clauses. A request in this regard is made within 5 years of his entry into government service. 5 years within. It is clearly established that a genuine bona fide mistake has occurred. And lastly, the date of birth so altered will not make him ineligible to appear in any school or university or union public service examination in which he had appeared or for entry into government service on the date on which he had first appeared at such examination or on date on which he had entered government service. The petitioner is seeking date of birth, a correction of his date of birth in terms of this notification.
Within 5 years?
Yes, Your Lordship, I have appointed in the year 1990.
1990.
Yes.
So he,
I have made my representation in 1992. So
Okay.
therefore, I have made my representation for the correction of date of birth within this 5 years.
So why are you coming to this court now? This is how many years? 2024.
Your Lordship, I have submitted my representation in the 1992, but since then my representation has not been considered in terms of this notification. They are, Your Lordship, merely denying my representation on the ground of clause number C of this notification. They are saying that I was appeared in class 10 matriculation at the age of 13 years. So the minimum age required to appear in matriculation was 14 years. However, Your Lordship, I have passed my matriculations from the UP, Uttar Pradesh, and there was a judgment of the Honorable High Court. Your Lordship, kindly take my affidavit in reply, Your Lordship. Affidavit in reply, Your Lordship, filed by me. Your Lordship.
Wait just a sec. Affidavit in reply. Okay. This is an additional affidavit.
No, Your Lordship, affidavit in reply.
Let me see. Affidavit in opposition has been filed. Yes, affidavit in reply.
Your Lordship, in this my reply, I have made categorical statement that the clause C will not applicable in case of me. That paragraph 3, Your Lordship.
Para 3.
Yes, Your Lordship.
Okay.
May I read your
Yes,
paragraph?
yes.
That in regard to paragraph 4 of the affidavit in opposition of respondent number 1, 2, 3, your humble deponent vehemently denies the same, begs to submit that this is not necessary, Your Lordship. Next page, Your Lordship. Next page, page number 4, Your Lordship. The argument of respondent number is not tenable, since it is based upon presumption that when someone takes admission in primary classes, then he will clear one class in 1 year only. The petitioner took admission in class 1 in 4 years of age, and thereafter 2 classes were cleared in 1 year. In those times, there was no minimum age prescribed for taking admission in class 1, like the present days. Moreover, the primary education petitioner took place in the Tehsil of District Lakhimpur, Kheri. The petitioner passed 10th from UP Board of Education, and there was no minimum age prescribed for appearing in the matriculation examination. In this connection, the decision of Honorable High Court Allahabad in case of Board of High School and versus Gopal Naren Singh, equivalent status AR 1973, Allahabad 343, is enclosed here, wherein the Honorable Allahabad High Court has held that Directive of State Government dated 23/12/1965, as well as Regulation 33, whereby it was provided that the candidate shall be eligible for admission to the higher secondary examination of 1971 and onwards, unless her age on the 1st July of the year in which she intends to appear at the examination is 14 years or more, suffered from the vice of discrimination in violation of Article 14 of the Constitution of India.
So where's the judgment?
I have annexed, Your Lordship.
You've just taken it.
It is start from page number 20 onwards, annexure 1 of my affidavit in reply, Your Lordship. So therefore, Your Lordship.
Wait, I'm not seeing the judgment.
Page 20 onwards, Your Lordship.
Okay, yes.
So this is the judgment of the Honorable High Court Allahabad. So I passed out from the UP, Uttar Pradesh.
Okay, at what age? 13? 13 years? You
Yes,
were
yes.
13 years when you cleared your
Yes,
class
13 years.
10. Okay.
So there was no minimum age required to appear in the matriculation certificate. So clause number 3 is not applicable in my case, Your Lordship. The only thing which is to be considered is whether I have made my representation within the period of 5 years as per the notification, and whether the mistake was genuine or no. So I complied all these clauses. So authority concerned ought to have considered my case in the year back 1992. However, they have disposed my representation.
When did they dispose of your representation?
The first they have disposed my representation in the year 1995, but the same has not been communicated to me, Your Lordship. I have come to know about the disposal of my representation only in the year 2018, Your Lordship. Thereafter, I have made subsequent representation, Your Lordship. They ought to have communicated me that your representation has been disposed of without considering your grievances. This thing has not happened, Your Lordship. Therefore, Your Lordship,
Let's see a copy of your first representation, 2018.
No, Your Lordship. First representation I made in year 1992, Your Lordship. It is page number 54 onwards, Your Lordship.
No, 1992, you made your first
Yes, Your
representation,
Lordship.
which was rejected.
Yes, Your Lordship.
Okay.
Yes, Your Lordship.
Then you got to know in 2018. You
Yes,
said.
Your Lordship.
So where's your representation, 2018 representation?
It is, Your Lordship, page number 69 onwards. Your Lordship.
Of your
Writ petition, Your Lordship.
writ petition. Okay. Yes,
May I read?
September 2018, yes. Huh.
From clause number 2, Your Lordship. The case seeking correction of date of birth was submitted to competent authority by application dated 30 April 1992. The disposal of application by the competent authority by Secretary such and such dated 9 August 1995 has been communicated by HQDGBR letter number 14501/DGBR/Gen/163/E1B dated 23 July 2018. Since the headquarter DGBR letter number 14125 DGBR/BKG/XY/E1B dated 23 August 1995 addressed to headquarter Chief Engineer P. Setu containing decision of CA on application dated.
Okay, fine. This is the army.
Yes, Your Honor.
The
The
army.
petitioner is serving as chief engineer in the grave, Your Lordship.
Okay.
In this representation also, I have specifically mentioned that was not communicated to me, Lordship. They have disposed my representation in the year 1995, but the same was never communicated to me, Lordship. As a result, the undersigned has come to know about the said disposal of application dated 30 April 1990 by letter mentioned above under reference only. Your Lordship, this reference is page number 68, whereby they have communicated to me. The decision which they have taken in the year 1995, it is in page number 68.
Yes, yes. So you made your representation in 2018. Then after that, what happened?
After that, Your Lordship, I have filed series of application, Your Lordship. After the representation of 2018, Your Lordship, they have forwarded the same. And again, Your Lordship, they have not considered my representation, Your Lordship. However, Your Lordship, there was a findings made by the authority concerned. It is in page number 74 onwards. There was a categorical, Your Lordship, statement prepared by the authority concerned, Your Lordship. May I read this?
Yes.
Since it is important, Your Lordship. Page number 74, Your Lordship. Statement of case in respect of GO 2130 at CE Civil Bimal Goswami for correction of his date of birth in service record. 1 GO 2130 at CE Civil Bimal Goswami joined BROS EE Assistant Engineer on 2nd December 1990 by way of his appointment letter issued by the Government of India BRDB bearing number F.54 under bracket 19/89 state dated 5 March 1990. This is the joining report and my appointment.
Okay, I'll just break you here. Your correct date of birth is 1960? 6. And in your service record, it was
It is
entered
written
as?
as 64.
Okay, so 2 years. You're claiming 2 years this thing.
Yes,
Is
Your
it?
Lordship.
Okay.
Only 2 years.
Hmm.
The aforesaid officer found
Anyway,
that.
it's time for lunch. We'll continue at 2.
Okay.
Time to Malada intervene in the matter. Malada, in this case, this officer has already retired.
Oh, he's already retired.
Yes, 2024.
So
31st August 2024, he has already retired.
24, huh? So what is
So
the effect of?
otherwise also, Malada, if the writ petition is allowed, Malada, it is not going to.
Then he'll have 2 more years of service
Yes,
if it is allowed.
allowed then.
Then I
But
think
the thing is, Malad, since we have already filed the affidavit also, Malad, and he has already been retired. Now we are in the month of October, Malad.
when did he retire?
31st August 2024, Malad.
31st August.
2 months back, Malad.
When was the writ petition filed?
It was filed in the year 2023, Malad.
23.
Sorry, 24, 22.
22.
22.
Yeah.
22, Malad.
And the matter has been kept pending.
Your Lordship, there were some development like
It had
we
been
have.
disposed of before the retirement, no?
Yes.
22. So what happens now?
Your Lordship, we have filed representation. And during the pendency of the writ petition, they have disposed my representation again without considering my grievances. Your Lordship, for that I have filed I also for setting aside of the Your Lordship that disposal order of my representation, Your Lordship.
And this is the retirement.
Your Lordship, it is admitted that he has been retired, Your Lordship, but it will cause great injustice to the petitioner, Your Lordship, because petitioner's representation has never been considered in accordance with the notification issued by the Government of India, Your Lordship. Your Lordship, I'm still ready to serve the nation, Your Lordship. I'm still ready to do my service, Your Lordship.
So just supposing the writ petition is allowed, can he be again reinstated? Is there such a prayer? in your writ petition?
Your Lordship,
So what happens?
Your Lordship, this is
No, this is a complicated matter. I'm just
this
asking, what do
this
we
is
do?
now
Supposing-
complicated.
Huh,
This is now
huh.
complicated. But this complication has been created by the authority concerned.
Huh.
If my
Supposing your writ petition is allowed and we say that your date of birth has to be accepted as what you are saying is
Yes.
2 more years, you'll have 2 more years.
Yes.
Then what will happen? The state will have to reinstate him?
Correct, ma'am.
Hmm. Then he has a case.
No, my lord, apart from that,
Mhm.
as per our affidavit, my lord, though as per the notifications, he is claiming, but my lord, as per the notification, the clause 3 is the operative portion, my lord.
Mm-hmm.
The clause 3 which, by which notifications, my lord, it is clearly stated, number 1. Number 2, my lord, the original date of birth is not yet corrected, my lord. So, my lord, the correction as per the notifications issued by the, my lord, the ministries is will not also covered in his cases. It's because the past matriculation certificate has to be corrected, madam.
So.
And this is not the case.
He prayed for the alteration of his date of birth.
Date of birth,
By
as per
saying
our
that
service
he-
record,
Huh.
not as per the, my lord, the record of the original, my lord, date of birth certificate issued by the, my lord, the school authorities and the
The
date of birth.
authority says his date of birth is what?
Same, my lord, as per the service record, it is 31st August 1966, my lord.
So based on what are you praying for the alteration of your date of birth? Based on what document?
based on the birth certificate issued by the registrar. Your Lordship, I have
So
annexed.
he's saying that we should depend on the birth certificate and not the school leaving certificate.
Yes, Your Lordship, as I
That's
have,
the submission.
as I have already submitted,
Qualification.
confirmatory evidence is register certificate, extract from the registrar. Your Lordship.
So his plea is on the birth certificate,
My lord,
not
based on,
not the school leaving certificate.
my lord, school leaving certificate is very important as because by virtue of that qualification, he has been, my lord, appointed in the department.
So correctly, the
But-
state government, as per the school leaving
School leaving.
certificate, they have accepted
That
that
has to be
document
first correct, madam.
submitted.
Without
But now
approaching
he's
us,
saying that my birth certificate is different from the school leaving.
yes, madam.
So he's asking the government to accept his school leaving certificate, not to accept his school leaving certificate, but to accept his birth certificate.
Birth certificate, that has to be corrected from the, even from the, my lord, the school leaving certificate, other old documents, not, my lord, approaching the department directly. Department has no authority to correct the, my lord, the date of birth certificate issued in the school records,
No,
madam.
so his submission is you accept my birth certificate, not my school leaving. That's his main contention. So we have to see on that point, whether it is the birth certificate that has to be accepted by the respondents or the school leaving certificate.
School
I
certificate.
think that's the point. Because you're saying that I am actually, this is my birth certificate, which should be accepted and not the school living certificate. So let's see the ground of rejection of your school birth certificate. Impugned order, there must be some impugned order against whom you have approached.
Correction of date of certificate, my lord,
Impugned order is which?
page number 79 of writ petition, madam. 77, my lord, it starts from operative portion is,
So basically, we'll have to look at the impugned order. What is wrong with this order?
my lord,
Not accepting your birth certificate,
my lord.
isn't it? I
Yes,
think we'll just come down to that point. Anything else? That's the main thing, isn't it?
Yes, Your Lordship.
Yes,
Ah.
Your Lordship, first thing, as my senior has submitted that, as per the clause C,
Hmm.
my case could not be considered. However, I have already submitted the Honorable Allahabad High Court.
So do they mention here clause C in 77? So page 77 is the impugned order, isn't it?
They never pass any speaking order, Your Lordship, while rejecting my
Okay,
application.
page 77 is, this is the impugned order, which is regarding the application for correction of birth certificate, which has been rejected, is it?
Yes,
So we'll look at this order. What is wrong with this order? What do they say here? Basically, I think we'll come down to that. This order, whether this order rejecting your birth certificate is a reasonable order or not.
Yes, Your Lordship.
So let's read the order.
Forwarding of, this is forwarding, as I have already, Your Lordship.
This is a reply to your this thing, representation.
Yeah, this is the forwarding made by the authority concerned. May I read, Your Lordship?
Yes, yes.
An application dated 10 September 2018 addressed to the Secretary, Ministry of Defence, New Delhi, regarding the subjects submitted by GO 002130F, Chief Engineer Civil Bimal Goswami of Headquarter STF Hirak Grab, is forwarded herewith duly recommended, along with the following documents for consideration by the competent authority for cadre controlling the authority. A recommendation of DDG, statement of case duly recommended by ADG Bar. Statement is page 70.
So D is copy of the matriculation mark sheet, isn't it?
Yes, sir.
Showing birth certificate as 1964. You're saying this is wrong,
Yes.
isn't it? So E is the copy of the birth certificate.
Yes, Your Lordship.
Now,
Issued
in
by the
birth-
Nagar Palika.
Yes. So dated so and so. Now, in the birth certificate, it says 1966. Is it?
Yes, Your Lordship, 1960.
Okay, that is not mentioned. Okay. Then.
Photocopy of Government of India Ministry of Home Affairs. This is the notification, Your Lordship. This is the same notification, subsequent notification. Photocopy FG and H are the this notification for the correction. In this connection, it is also intimated that above named officer had represented for change of his date of birth in the service record 2 times earlier by his application dated 30 April 1992 and 10 December 1994 respectively. In this connection, please refer BRDB letter number, PN number dated July 1992 and dated 9 August 1995.
So what about these two letters? What do they say? 1992 and 1995? Are they regretting the change of his birth or what? What is these two letters?
This is
So
Your
now
Lordship.
this letter duly recommended.
Your Lordship, it is page number 64 only.
So wait, just come to page 78. In view of the above, it is requested that the case for alteration of date of birth of the officer in his service record may please be reconsidered.
As per rule, as recommended by DDG.
So they are recommending.
They are accepting that my case is fit to be considered, Your Lordship.
Yes. So then what happens?
And if we see the Lordship, their findings, Your Lordship.
Then page 79.
Page 79, Your Lordship. Please refer para 3 of your letter mentioned under reference and officer's application dated 10 December 95 mentioned in para 5 of your letter number such and such 19 July 2019. The application of the officer by dated 10 September has clearly brought out by para 3 that contents of the such and such dated 9 August 1995, which state that rule position does not permit for correction of date of birth. This is the finding, Your Lordship. Rule position does not permit for correction of date of birth are contrary to the department by such and such dated 10 September have also requested for the speaking order. Speaking order was also, Your Lordship, called for. The officer has also brought into his application dated 10 September 2018 that such and such 9 August 1995 was received by him by letter number such and such dated 23 July 2018 and not before. No evidence either has been produced regarding receipt of communication by him post officer application dated 10 December 1994. It is seen that speaking order has not been issued by the competent authority and they have asked for some clarification and resubmission of case. Therefore, it is requested that the case to be resubmitted to Ministry of Defence so that speaking order can be issued by them.
So any speaking order issued, this is
No, no, any speaking order. Then subsequently page number 18, Your Lordship. Clause number,
Is what?
this is again forwarding, I guess, Your Lordship. Correction date of birth instead of 31 April.
So it has been regretted, isn't it?
The ministry asked me to submit my representation before the concerned authority, Your Lordship. Therefore, Your Lordship, on October 4 2019, I have submitted subsequent representation, Your Lordship. While it is all my grievances, Your Lordship, in detailed manner, I have submitted my representation and
Again,
it is in page number
so
81.
fit for reconsideration of change of date of birth.
Yes, Your Lordship.
So this is 26 September, which says that the matter is fit for reconsideration.
Yes, Your Lordship.
Then
After, Your Lordship, at page
4th
number
October.
4 October 2019, this is the application that I have submitted, Your Lordship.
So you have for reconsideration, so you have submitted your representation on 4th October. Then what happened?
Then this application was forwarded, and finally, Your Lordship, I have filed one IA, Your Lordship, interlocutory application. My application 4th October 2019 was, Your Lordship.
Wait, let's look at all your documents. So in page 83, your representation was forwarded.
Yes, Your Lordship.
Further submission to headquarters, DGBR. Okay, so this is, then what happened after that? 84 is what?
Your Lordship, my application was considered, again disposed of, without considering my grievances. Your Lordship, you
Where's
will
that?
find an IA, Your Lordship. I have filed one IA, Your Lordship.
Okay. So there was an IA, which
Yes,
has
Your
been
Lordship.
disposed of, or it's still pending this IA?
It is pending, Your Lordship. Since the main grievance in my writ petition is same in this IA, because they have disposed my representation, Your Lordship, during the pendency of this writ petition. Therefore, I have filed this IA for setting aside of my representation disposal order, Your Lordship. Your Lordship will find at page number 17 onwards.
So this in the IA, page 17, it is a letter which is dated as recently as 2023.
Yes, Your Lordship.
So in this letter, a photocopy of the Ministry of Defense, so and so, on the subject matter, which is self-explanatory.
Your Lordship, the finding is in page number 18, Your Lordship. The subject case has been re-examined in the ministry. It has been observed that officer has made no conclusive efforts to amend his date of birth in the confirmatory documents, that is matriculation certificate, admitted at the time of joining. Therefore, it can be concluded that the decision taken by the competent authority by BRDB letter number 9/8/1995 stand good, and the subject case is not fit for reconsideration at the belated stage.
So
Now,
their reason is that the matriculation certificate has not been corrected.
yes, Your Lordship, that is their case, Your Lordship. However, Your Lordship, I have already read the notification of the Minister Board in confirmatory evidence, Your Lordship. The extract from the register. So I have, Your Lordship, obtained my date of birth from the register itself, Your Lordship. And it can be taken into account for the consideration of my date of birth, Your Lordship, as per this notification issued by the
Let's
government.
come back to the notification. Now we are clear with the facts. Now let's come back to the notification.
Clause 3 is specifically
Wait,
covered.
Page
Page, my lord, type copy is 37, my lord.
36.
36, Your Lordship.
37 is the operative portion, my lord.
Page
C,
37.
clause C.
My brother is stressing on this clause C, Your Lordship. Since it is, Your Lordship, make me ineligible to appear in the matriculation. However, I have already shown the judgment from the Honorable High Court. So therefore, this clause will not applicable in my case. And regarding the confirmatory documents, Your Lordship, note 5, may I read again, Your Lordship? Page number 36, note 5. The
Yes.
date on which a government servant attains the age of 58 years or 60 years, as the case may be, shall be determined with reference to the date of birth declared by the government servant at the time of appointment and accepted by the appropriate authority on production, as far as possible, of confirmatory documents, evidence such as high school, higher secondary school certificate, or extract from birth register. Extract from birth register, Your Lordship, I would like to take you to page number, Your Lordship, 52 of my writ petition. Page number 52. Page number 53 is the type copy. This is the birth certificate that I obtained from the registrar, Your Lordship. It is a competent authority. And as per section 15 of the, Your Lordship, the Registration of Birth and Death Act 1969, Your Lordship.
So what appears in this case is that you had not informed them of your correct date of birth because at that time you were too young and not eligible for class maybe 10. Is it school living? So
Your
maybe you had given them a wrong date of birth, and now after you're in service, you feel that, okay, actually I should have used my real date of birth because then I'll have 2 more years. It appears like that. That is your case.
Your Lordship, genuine mistake was committed while filing the matriculation form, Your Lordship. It is admitted in my writ petition, Your Lordship.
You did not conceal date of birth, is it? Or maybe you were concealing a date of birth because you were not eligible then to sit for the exam.
No, Your Lordship, the law is settled, as per the judgment passed by the Honorable High Court, Allahabad, Your Lordship. The minimum is not required to appear for the matriculation, Your Lordship.
This is UP.
Yes, UP, yes, Lordship. I was passed out
That
from
is
the UP.
Allahabad.
Yes, Allahabad. It was the judgment was passed in 1979, sorry, Your Lordship.
You see, we're just trying to find out why is this different date of birth. So if it is in 1966, then you would have been how old when you passed your matriculation?
I was 13 years old.
13. That means 1 year deficit.
Yes, Your Lordship.
Should be 14.
But as per this judgment, Your Lordship, minimum requirement for appearing in the matriculation is not necessary, Your Lordship.
So the respondents are saying that
They are only stressing
we
in-
should rely on the school living certificate, which has not been changed, and that though the date of birth says 1966, however, they have not approached for the correction of the school living certificate. I think that's a basic ground, isn't it? The respondents. Respondents, your basic ground is that even though the date of birth is showing 1966,
My lord.
since the school living certificate has not been changed, you are correct in depending on the school living
certificate.
That's your submission.
Subsequently, my lord, the date of birth certificate, my lord, that has not been even placed to our the department, my lord. Registration certificate, my lord. Now this, my lord, and that is another the contention of the, my lord, the respondent
Okay,
department
this date of birth certificate
is not
was-
corrected so far, my lord. The registration certificate which my learned brother is relying upon is not even we don't know, my lord, that is not placed before the, my lord, the department.
Okay, have you placed your?
Yes, Your Lordship, I have enclosed my birth certificate along with my representation. Only after, based on this document, I can.
My lord, that correction has to be done within a certain limitation, my lord, within a certain period. Therefore, my lord, if lordship, my lord, to again peruse the, my lord.
So after 2 years, you
Yes.
approach the concerned department after 2 years, isn't it?
Yes, Your Lordship.
After being,
Within the time limit, Your Lordship. It is 5 years, so I have approached the concerned authority within the time limit.
So when you approach the concerned authority within the time limit, did you enclose this birth certificate?
Yes, Your Lordship, I have enclosed, Your Lordship. Without enclosing this document, how can I rely that my age is that and that?
Lordship, may kindly peruse again page number 37 of writ petition, my lord.
37.
This is the, my lord, all things, my lord, that have
Only
not
on
been-
this ground,
Yes.
37.
The date of, my lord, it is not that
So
case,
it's the same thing. The date of birth so altered would not make him ineligible
my lord.
to appear in the, so you're saying that this date of birth will make him ineligible?
Ineligible, my lord. If altered, my lord, it is ineligible. And my lord,
Because you're saying because he would be 13 years.
yes,
then.
my lord. And
then he has relied on the judgment of the Allahabad
11
High
High Court,
Court.
my lord. I don't know, my lord, the 11 High Court, there is separate rules, my lord, the separate guidelines, my lord. It seems, my lord, as per the document, my lord,
So, but
the-
he had obtained his, this thing, school living certificate from which, place, from
Uttar Pradesh itself.
UP?
Yes, Your Lordship.
it is in, my lord, annexure.
Page 52
Hello.
onwards.
So show me the rules. Which says that if you are of 13 years of age, you are not eligible to appear for the school leaving certificate exam.
My lord,
Where's that?
that rule is not, my lord, that is as per the, my lord.
For the UP, because
No,
he
that-
cleared
that-
from the UP board.
UP board, that is, my lord, the different case, but in our case, my lord, it is, my lord, page number, my lord, affidavit in opposition filed by, my lord, the Union of India, my lord.
Yes.
Annexure, my lord, annexure, my lord, the basic contention is at page number, my lord, 3, third paragraph, my lord.
Affidavit in opposition, yes.
Para 4, my lord, page,
Para 4,
my lord,
yes.
para 4.
Yes.
The Department of the Personal Administrative, so and so, 1979, so and so, memorandum, so and so, so and so. The government, they give the opportunity to a government, hereinafter will be referred to as gov, employee to alter his date of birth under certain conditions. However, the petitioner does not come under the clause C of the OM that the date of birth so altered would not make him ineligible to appear in any school or the university or the public service commission, a public service examination in which he had appeared or for entry into government service on the date on which he passed at such examinations or the date of which he entered government service. Two aspects. One is first school, first examination, and as well as the service, the training in this department.
So when he joined the service, if he was born in 1966, how old would he be?
I was almost
Above 80?
25 years above you.
Hmm.
Because I was born in 1966 and I was appointed in the year 1990, Your Lordship. So therefore, 24 I guess. Your Lordship.
And
Or
that is
in which he appeared or for entry into the government service. Huh? So when he entered into the government service, he was eligible.
Yes, Your
His age. If he was below 18 years, then we cannot consider the alteration of his.
my lord. So therefore, my lord, that is the conditions of the department, my lord. The next paragraph, my lord.
Mhm.
In the instant case, in the present case, the petitioner wants to alter his date of birth is 31st August 1966 from the existing date of birth 31st August 1964. But it makes him ineligible for admission in first standards at the age of 3 years instead of 5 years. And further disqualify him from appearance in the subsequent examinations, that is, appearance in the matriculations examination in 1997 at 13 years instead of 15 years, and higher secondary and intermediate examination in 1981 at the age of 15 years instead of 17 years.
So many notifications where he is not allowed to appear for the matriculation at that time.
Well, admittedly, there is no notification as
There
per
should
the-
be then then what, on
Madam,
what basis?
Now the government policy is very clear.
Now the government,
Yes.
but now at that time.
At that relevant point of time, admittedly, my lord, but my lord, at that relevant point of time, even I myself, my lord, admit in the got admitted in the class 1 standard at the my lord, after attending the fresh cafe age. So at that time, normally, my lord, at that relevant point of time, the students, my lord, the youth, got admitted not
Very
below
early.
certain age, my lord.
Oh.
But after attending the maximum age, my lord, instead of 3 years, it should be 6 or 7 years.
Now it is like that.
Now, my lord, at that relevant point of time, it was more relaxation
Oh.
as per the present notification.
So unless you have something to base this yardstick, isn't it, for appearance in matriculation examination, 13, give us something from the educational department, if not.
And my lord, that is the my lord, another my lord, the first my lord, the limb of
Huh,
contentions
that's
of
the
the part
first
of the my lord,
point,
rest of the department. And my lord, more particularly, the another my lord, date of birth is my lord, very much clear. Annexure 2, page number my lord, 24. Date of appointment is 1990,
90.
my lord.
Huh.
And the date of birth is also specifically mentioned.
1964.
Nine.
So after 2 years after this, he had come for alteration of his date of birth, isn't it? Saying it's my school matriculation, school living certificate
At the
date
age
of
of
birth is wrong, and that this is my correct age.
my lord, at the age of 24 years, my lord.
Mm.
And my lord, another my lord, the contentions of the department is regarding department is relying upon the judgment and order, my lord, the
Yes.
judgment of the Honorable Supreme Court,
Ah,
wherein my lord, specifically it has been mentioned that
yes.
the bar of examination, my lord, the bar of altercation of the age except
Okay. What is the operative part? What do they say?
basically my lord, the delay in this is my lord. Page number 62, it starts from my lord.
62.
My lord. Para 10, my lord. Department is time and again, my lord, saying that there is a delay in license, my lord, on time, my lord, he is not approached. Therefore, my lord, the clause C is, my lord, applicable in our case, my lord. Application for change of the change of date of birth can only be as per the relevant provisions, regulations applicable. And even if there is a cogent evidence, the same cannot be claimed as a matter of right. 3, the applications can be rejected on the ground of delay and latency also more particularly when it is made at the vague end of service or when the employee is about to retire on attaining the age of superannuation. So this is exactly covered in our case, Melanda. Now he has been retired and so therefore, applying the law laid down by this court in the aforesaid decisions, the applications of the respondents for the change of the date of birth was liable to be rejected on ground of delay and latency also, and therefore the respondent employee was not entitled to the degree of the declaration. And therefore, the impugned judgment and order passed by the High Court is unsustainable and not tenable at law. Well, the rest are also the observations of the Honorable Supreme Court.
Who is the appellant in this case?
Well, it was
No, I'm just saying that because here it says that however, question of law is decided in favor of the appellant.
It is Bharat Cooking, Matlab, All India and others, Matlab, appellant is.
Okay, so this means
The
if they have a
employee, Matlab, employee, respondent is Siam Kishore Singh, Madam.
So in this case, the
Date of birth was not corrected by the
division
department.
bench had allowed
My lord.
the
Yes.
amendment of the date of birth.
Yes.
Okay.
So the Bharat Cooking is a company organization wherein the Siam Kishore Singh was
Okay, on grounds
employee.
of delay.
Yes.
Basically.
And the Bharat.
So we'll have to look at the facts.
My lord.
Okay. Whether your judgment you're relying is applicable in the instant case
My
or
lord.
not.
Your Lordship, may.
No, yes.
The judgment relied by my senior, Your Lordship. It is not applicable in the instant case because on those cases, the petitioners were approached at the fake end of the service. However, in my case, Your Lordship, it is admitted by the competent authority itself that he has submitted representation before the, Your Lordship, within the time limit, Your Lordship.
So we have to see whether your application is barred as per the notification. Clause 3, you say it, isn't it? Anyways.
Clause 3.
We'll make it a CAV, but I'll record your submissions so that I can. Okay, heard, Mr. Ilabami, Learned Counsel for the petitioner, along with Mr. N. Labang, learned additional
Yes, yeah.
additional AG. Is it?
Your Lordship,
Body?
sorry for the interruption. Your Lord, I may be allowed to submit one judgment. Your Lord.
Okay, one more judgment, huh? What does the judgment say?
Your Lordship, I'll read the only operative portion. 1994 supplementary 1 SSC.
The citation is?
1994 supplementary 1 SSC. Page 155.
155.
Yes, Your Lordship. Paragraph 7, Your Lordship. From the from the bottom last line.
No, read the whole para, little bits and pieces of the line.
Okay, Your Lordship. An application for correction of date of birth should not be dealt with by the tribunal or the High Court, keeping in view only the public servant concerned. It need not be pointed out that any such direction for correction of the date of birth of the public servant concerned has a chain reaction in as much as others waiting for years below him for their respective promotion are affected in this process. Some are likely to suffer irreparable injury in as much as because of the correction of the date of birth. The officer concerned continues in office, in some cases for years, within which time many officers who are below him in seniority waiting for their promotion may lose their promotion forever. Cases are not unknown when a person accepts appointment keeping in view the date of retirement of his immediate senior. According to us, this is an important aspect which cannot be lost sight of by the court or the tribunal while examining the grievance of a public servant in a respect of correction of his date of birth. As such, unless a clear case on the basis of materials which can be held to be conclusive in nature is made out by the respondent, the court or the tribunal should not issue a direction on the basis of material which makes such claim only plausible. Before any such direction issued, the court or the tribunal must be fully satisfied that there has been a real injustice to the person concerned and his claim for correction of date of birth has been made in accordance with the procedure prescribed and within the time fixed by any rule or order. In this case, Your Lordship, my case is fit to be considered because I applied for the correction of date of birth within the prescribed procedure and within the prescribed time, Your Lordship.
You see, but one thing is, you had applied after 2 years. You made many applications. It was rejected.
Yes, Your Lordship.
After if it was rejected, how many years did you take to come to the court?
Your Lordship, after this, my representation was disposed in the year 1995. It was not known to me, Your Lordship. I was of the impression that my date of birth has been corrected, Your Lordship. Only in the year 2018, I came to know about the disposal order, Your Lordship. Then afterwards, I have submitted series of representation before the authority concerned. But till that, they have disposed my representation without following the due process of this settled notification.
Okay. Yes, so heard Mr. So-and-so, learned counsel for the petition. Who is? One instant written petition for setting aside the notification dated, which one is the one? Where your representation was rejected?
The last
Notification dated, is it? Mm, Where's the latest notification rejecting your prayer?
Your Lordship,
For
it is in
alteration of your birth certificate?
it is in Your Lordship.
IA.
Yes, Your Lordship.
Dated what?
Dated, it is 5th April 2023, Your Lordship.
So in the IA it is there, but in your writ petition, it's not mentioned?
Yes, Your Lordship.
Why? Why isn't it
After
mentioned?
this filing of this writ petition,
Ah.
they have disposed my writ petition during the pendency of this writ petition. So therefore, I have
Let's
decided.
see the IA, what is the date? See, your case is
I
not
was
nice.
filed
Ah.
on 11 July 2024. Your Lordship.
So when you filed the instant writ petition,
It was filed in.
your representation was still pending?
Yes, yes. It was pending, Your Lordship. The last representation. I have filed my representation in the year 2022. My representation, last representation of this was on year 23. So therefore, I filed this IA, Your Lordship.
Anyway, we have to look into the writ petition first, isn't it?
Madam, para 3 is clear, madam.
Para 3 of what?
IA, page 18, madam.
See, but we are dealing with the writ petition right now. The IA, subsequently the IA, that's a different matter. But when you file the writ petition,
It can be additional evidence, actually, it should be additional.
actually, so you filed an IA. When we are dealing with a writ petition, then if there was an, yes, maybe an additional affidavit incorporating the instant, that's how it should have gone about.
Yes, Your Lordship. It ought to be in additional affidavit form. But in additional affidavit form, we cannot make any specific prayer, Your Lordship.
So you could
So
have filed,
therefore,
you should have filed an additional affidavit. Okay, and then after you file an additional affidavit, you could have filed the IA, where you will make the prayer for staying of the, or for setting aside the impugned whatever order. Isn't it? That's how it should have been done. Because otherwise,
Madam, what it specifically
it
says is.
complicates the whole matter.
Yes, ma'am. Therefore, it can be concluded that the decision taken by the competent authority by DGB, BRTB, letter dated 9 August 1995, sorry.
So in the IA,
IA.
the IA, the letter is there. But we are dealing with the writ petition. In the writ petition, when you initially submitted your writ petition, there was no letter which is dated, which was just read out, 2023, isn't it? So when we're dealing with the writ petition, that letter we cannot mention.
It was communicated long years back, 9 August 1995, and it stands good, and the subject case is not fit for reconsideration at this belated stage, madam.
Okay, filed the instant writ petition. Instead of setting aside writ petition for a direction to make necessary correction slash rectification of his date of birth in the service record, which was recorded as 31st/08/1964, to be corrected as 31/08/1966. In accordance with the notification dated 30 November 1979, issued by the Government of India, Ministry of Home Affairs, DPNAR, dated 15/12 1979. Wherein the petitioner had made an application for the correction of his wrongly of his wrong date of birth within 2 years from his joining of service. By submitting his correct date of birth through a birth certificate issued by the
Executive Officer Nagar Palika.
by the executive officer, Nagar Palika Prasad, Gola Gukaran Nap, within brackets, Kerry, wherein his correct date of birth was recorded as 31st/08/1966. Wait, now look at this document. Now, the date of registration of this document is 27/01/1992.
Yes, Your Lordship.
You joined service in
1990, Your Lordship.
1990.
Yes, Your Lordship. 2nd December 1990, Your Lordship.
So when you joined service, you did not have this document.
No, Your Lordship. Therefore, Your Lordship.
That is the
Subsequently, you are after joining service. So there's no way that your date of birth can be recorded correctly. And it's only after you have joined your service that you went and obtained your date of birth like this. How can that be? On what basis is this date of birth issued?
normal practice is, my lord, as per the, my lord, the normal practice, my lord. If that part is to be corrected, my lord, it has to be corrected from the date of birth registration as well. And that has to be duly published in the, my lord, newspaper, local newspapers in two local newspapers.
See, he's getting a date of birth certificate after he's joined his service, where it was recorded as 1964. Is there some malafide involved in this matter? That's what I'm wondering.
Your Lordship.
See, because when you obtained your school living certificate, okay, at that time, your only record was your date of birth is 1964.
Yes.
So there was nothing wrong in the registration when you joined service that your date of birth is recorded as 1964 because that was the only certificate you have. Now, after joining service, 2 years after joining service, you go and obtain the date of birth certificate in 1992 after you joining this thing. How is that?
And again, my lord, that is not corrected in the degree certificate.
No, school living you cannot correct because you cannot go back to school and say this is my this thing. That's okay.
In
That's a different
certificate, my
matter.
lord, degree certificate it
But
has to be.
on what basis is this date of birth issued, which is issued in 1992?
Your Lordship, there is a
After your joining service, if it was issued during the time when you were born, okay, at that time, 1996, around that period, you already had a what birth certificate, but in your school leaving certificate, something was wrong, and then it was shown as 1964. Then it's a different matter. But this is long after you were born. You joined service, and then you suddenly come up with a birth certificate. On what basis? After how many years are they issuing? How do you issue and here translated as from original? So that we have to see whether something is happening. This is in the what language? Hindi language. Is
Hindi-
it the
Hindi.
original?
yes.
After you join service, you go and get a correct date. So how did you know that your date of birth was 1966?
Yes, Your Lordship, it is mentioned in paragraph 8 of my petition. Your
How
Lordship,
did you get to know? You did your schooling, everything. Then suddenly after you join service,
it was
you
only
find that you have to be 2 years younger, and then you go and go to the what death and birth this thing and get your fresh birth certificate.
Your Lordship, kindly peruse page 13, paragraph 8 of my petition. The reason I have mentioned
Page
here.
13,
Yes, Your Lordship, paragraph 8, Your Lordship. of my
para 8.
petition. That the petitioner begged to state that while filing the form for high school examination, a genuine mistake of entering a wrong date of birth year had been committed by the petitioner. As such, the father of the petitioner was out of the city at the time, and the mother of the petitioner was not educated enough to fill the high school examination form of the petitioner, and therefore the petitioner himself had filled the examination form under the direction of the then teacher present at the time of filing of the examination form. The occurrence of the mistake of putting wrong entry of the date of birth year was known to the petitioner and his parents only after the high school pass certificate was delivered from the office of the school, wherein the incorrect date of birth year of the petitioner has been entered. As such, the actual date of birth of the petitioner is 31/08/1996. On being inquiry made by the father of the petitioner for the correction of the date of birth, which has been wrongly entered by the petitioner, he was informed that the same could be rectified only after taking the matter for consideration by the court. Since the step for the rectification and date of birth year mentioned in the high school certificate of the petitioner, it would have been a very costly proposition for the petitioner's parent, and hence he did not pursue the matter in the court for the rectification of the birth of year of 19 of the year of the petitioner. Your Lordship, then Your Lordship, the petitioner was, Your Lordship, came to know about this as I have already submitted only after the high school certificate has been delivered to him. Since they belong to poor family, they could not pursue for the correction. Afterward, petitioner was engaged in, Your Lordship, preparation for the competitive examination, and only after he being appointed in the year 1990, he would able to, Your Lordship, approach the authority concerned, Your Lordship. And as per the, Your Lordship, the Act, the Registration of Birth and Deaths Act 1969,
Let's see.
Section 15, Your Lordship.
What does section 15 say?
May I read, Your Lordship? Section 15, correction or cancellation or entry in the register or birth and death. If it is proved to the satisfaction of the registrar that any entry of a birth or death in any register kept by him under this act is erroneous in form or substance, or has been fraudulently or improperly made, he may, subject to such rules as may be made by the state government with respect to the condition on which and the circumstances in which such entries may be corrected or cancelled, correct the error or cancel the entry by suitable entry in the margin without any alteration of the original entry, and shall sign the marginal entry and the aid thereto the date of the correction or cancellation. Your Lordship, there is no specific time limit as per this act for the correction of date of birth, Your Lordship. It can be corrected in any stage, Your Lordship.
Anyways, we'll have a look. What is it? Last sentence? Oh, 90, and issued on 11/02/1992. The Learned Council submits that as per the notification, state notification dated 30th November 1979. Note 5. Okay, then this, the whole thing. Okay, this is page 36. This will be within inverted commas. He further submits that as per his date of birth, he would have been 13 years when he passed his matriculation. But this would not debar him from sitting for his examination. In view and in support of his point, he has cited the judgment of the Allahabad High Court in
The Board of High School,
where's the judgment?
it is in affidavit in reply, page number 20 onwards.
Okay, you look at the judgment. Okay, both of us will so also. Wherein the apex court held.
High Court, Your Lordship.
Page what? Page?
20, Your Lordship.
Page 20.
Affidavit in reply, page number 20. Your Lordship.
I think the cases, the Board of High School and dash dash versus Gopal Narayan Singh. Is this a reported case?
Yeah, equivalent citation AIR 1973 Allahabad 345.
Where's the citation here?
It is down below the name of the case, Your Lordship. Just below the case name.
Okay, AIR 1973, ALL 345. Wherein the apex court held that prescribing a minimum age. It just basically mentioned, if you look at the judgment, it's not justified, is it? Nothing is basically mentioned here. They have just, it's a long discussion.
Your Lordship, in paragraph 4, Your Lordship.
That will be the submission made by the.
Yes, Your Lordship. The respondent in this appeal sought admission to the high school examination held in 1970. Their application was rejected by the board on the ground that they were
Your submission.
below 14 years.
Oh.
Based on this, Your Lordship, notification, Your
This
Lordship.
is a submission made by the council, isn't it? So the decision.
In
of the
paragraph
court.
15, Your Lordship, the opinion of the court is there, Your Lordship.
Anyway, when this court set aside, when the court, okay, set aside the directive of the state government prescribing a minimum age for a student to receive higher secondary education. We'll leave it at that. I'll have to look at the full judgment, see whether it's actually that. Mm. The Learned Council further submits that the instant writ petition was filed on, when was it filed on? 07/03/2022. And during the pendency of the instant writ petition, the state respondents had issued a letter dated what's the date? Page 18?
68 is the communication letter whereby I came to know that my representation of this photo.
In the IA, dated
I'm not,
during the pendency,
Oh, Your Lordship,
you had filed an IA against the letter dated
but it was disposed.
page 18 of the IA. What is the date?
It is 5th April 2023, Your Lordship.
On page 18, are we on the same page? Here it looks like it is 10/5/2023. What's the
It
date
is
here?
the signature of the petitioner, so
So-
he might receive on that day, Your Lordship.
So what is the date?
It is
This was communicated to him.
10/5/2023. 10/5.
Where's the date? On page?
18, Your Lordship. After the signature,
So signature is the date when it was communicated.
Yes,
isn't it? So it's 10/5.
Your Lordship, it was
2023. Nothing is clear here. What have you mentioned in the IA?
It is Your Lordship, page number 17, Your Lordship. A photocopy of Ministry of Defense note such and such dated 5th April 2023.
Okay, dated 05/04/2023. And against this IA, he had filed, no, and against this letter, he had filed the IE 102 within brackets AP 2024. Which was to be disposed of along with the instant writ petition. In the said IA, the said letter dated so and so. Was also challenged. Wherein the representation of the petitioner for the correct entry of his date of birth from so and so 1964 to 1966 was rejected. The learned counsel for the petitioner has also explained the reason for the late issuance of the birth certificate which was issued on 11/02/1992 by stating that as per section how much?
15.
15 of the Registration of Births and Deaths Act 1969. The petitioner had taken belated steps in obtaining the birth certificate due to the fact that the petitioner, the parents of the petitioner, okay, being uneducated, had not taken the necessary steps for the correction or for obtaining the birth certificate, even though they were aware of the birth certificate, of the date of birth being wrongly recorded in his school leaving certificate. Since they did not have the resources to approach the court for making the necessary correction to the school leaving certificate, wherein his date of birth was wrongly recorded. Is that it? Anything else? The learned counsel has also cited the case of yes, Secretary and Commissioner, Home Department and others versus R. Kiru Bakaran. Okay. Reported in 1994 supplementary within brackets 1 SCC 155, wherein the apex court had held that if it is a clear case and on the basis of the material produced for the correction of the birth certificate, the court or the tribunal should not issue a direction for the correction of the birth certificate. The learned counsel submits that in the instant case, on the production of the birth certificate of the petitioner, this is a clear case with the required documents being submitted, and therefore his records of date of birth should be corrected. The learned counsel further submits that the petitioner had retired on
31st August 2024.
31st August 2024 on the basis of his wrong date of birth, and that he may be reinstated into service on the correction of his date of birth. So, anything else? I think that's it. Then Mr. M. Kato, learned additional AG, on behalf of the on behalf of the respondents, submits that the correction in the service record of the petitioner with regards to his date of birth was rejected as per Note 5, Clause C, wherein the petitioner would be ineligible to appear in the school leaving examination, since he would be aged only 13 years at that time, as per the birth certificate produced by him, wherein he is required to attain the age of 14 years. Is it to appear
15 years.
for the 14, isn't it?
15 years.
15?
Yes.
Okay, the age of 15 years to appear in this school leaving examination. Okay, that's one point. Then the learned counsel further submits that there has been no correction in the school leaving certificate.
No, madam, the degree certificate, ma'am.
Is it-
Education qualification certificate.
Okay, not school living.
No, ma'am. School living certificate is not required to be malada. For appointment is based as per the education
Okay,
qualifications.
there is no correction in his degree certificate.
Madam.
Okay. Wherein his date of birth has been recorded as so-and-so 1964. What is the date?
31st August
Oh, 31st
1964.
August 1964. And therefore,
And by which madam, by which year he was at the age of 24 years, and madam, it is selected through the union's public UPSC, madam.
wait. When it was recorded as 1964, isn't it? He further submits that the petitioner had joined service on, when did,
At the age of 24 years.
at the age of 24 years on, when did he join? On?
2nd December 1990, Your Lordship. That is my joining report and my
A joining
appointment
report, joint service on 2nd December
1990.
1990,
My appointment was on
wherein his age was 24 years.
24 years.
Okay.
And it could have made malada the render him ineligible by the Union Public Service Commission.
Okay.
madam.
Thus, if his age was to be recorded as so-and-so 1966, okay, he would be illegible to appear for the exam, is it?
Madam, UPSC examination.
UPC exam. Then he would be 22, isn't it?
Yes,
He'd
Your
be
Lordship.
illegible or what?
Eligible, I'm still eligible.
Anyways, that is their submission,
Madam.
okay? They appear for the UPC exam. Anything else? What is it? I think those are your 2 points. One is as per the rules and one is his age.
And my lord, after verification and everything, my lord, he has been selected through the Union Public Service Commission, my lord, and all the documents documents were verified by
The instant petitioner has been selected by the Public Service Commission after all due verification. And therefore, there are no grounds for altering the birth certificate from so-and-so 1964 to so-and-so 1966.
Madam. And another, my
There
lord,
was a judgment you have.
and another, my lord, contention is for correction, he has applied lately, my lord, and there is
Okay,
a
the
delay.
Learned Council also submits that
There is a delay in
the petitioner has applied for the correction of his date of birth at a belated stage, wherein at present he has retired from service on so-and-so, okay? And such an application should not be considered at this belated
Madam.
stage.
And relying upon the
In
matter.
support of his submission, he has relied upon the judgment of the apex court in, what is the?
Page number 29, madam, an
page
extra
number? Okay,
3, madam.
wait, in Bharat Cooking Oil Limited
My lord. And others.
versus and others versus Shyam Kishore Singh. Okay. Reported and where is it reported? Okay, we'll just make it in civil appeal number 1009 of 2020. Arising out of SLP, within bracket civil, number 20627 of 2019. That's it?
Madam.
Then having heard the submissions, so-and-so, okay, I'm looking to see it. Then in the main order, heard Mr. So-and-so, Learned Counsel for the petitioner, along with Mr. So-and-so, Learned Counsel for the Learned Additional AG for the respondents. Having heard the submissions made by the Learned Counsels for both the parties, hearing is concluded and the matter is reserved for.
Hello.
Yes.
My lord, the nutshell, my brief, the case is, my lord. I was first my transfer, my lord, I was transferred on 15 June 2023. Last year,
Where's the
I was
transfer order?
first
Page
transfer order at page 16, my lord.
16.
Yes. By this transfer order, I was transferred from Lepuriang to Balijan, present
Okay, you were what you are working as the
as assistant engineer, my lord.
engineer.
My name appears as serial number 2, my lord. Now, this is 15 June 2023, my lord. Now, my lord, I'm retiring next 8 months, within the 8 months. I'm retiring on June, my lord, of 2025. My retirement period is within the 8 month, my lord. Now, that is why I'm highlighting this month.
Your transfer order was on
15.
13th. It's 13th.
Yes, 15, my lord.
June.
My lord, down below it issued, or yes, 13 issued on 15 June, my lord.
Okay. 15 June 2023 is
Yes,
the
this
transfer
first.
order.
Now, my lord,
This is
guidelines.
the first,
Yes. Now, pursuant to this transfer order, I joined in the Balijan, my lord.
Yeah.
Now, my lord will see a guideline, my lord says.
Okay, you joined Balijan.
Yes, my lord.
Division,
My lord, at page 22, my lord see the guidelines of transfer posting. Page 22, my lord. D, my lord. Clause 1D, my lord. Officers are not to be transferred 1 year before retirement, as it may affect preparation of pension paper. However, generally, officer posted in the field division should be posted out to the office headquarters 1 year before retirement. Now, E, my lord, no transfer should take place in the last 3 months. No, my lord, the maximum tenure is, my lord, tenure is that 3 years, my lord, 3 years at B, my lord, above, my lord, B. All posting, including those in secretary and official, should be 3 years, my lord. Now this has been normally.
So,
Subsequently, this has been modified, my lord. Now present modified is, my lord, 2 years, my lord. Modified orders at, my lord, you see at page 26 is 2 years, my lord. Now, my lord, you see, subsequently, 2021, the government has instructed at page 28, my lord, you see. Now, this has been 2 years. Page 28, my lord, you see.
28.
Yes. Page 28, Government of Arunachal Pradesh has directed all departments to strictly follow this guidelines, my lord. 2 years of tenure and to categorically to follow this guideline 2008 and 1998, my lord. 1998, my lord, only the change was 1998, my lord, the tenure was 3 years, but so far, my lord, rules of the,
Now it's 2 years.
yes, 2 years. And so far, the retirement period, my lord, that one, the officer should not be transferred before 1 year of retirement. This is remain as it is, my lord. Now this has been directed, my lord, to be maintained strictly as per the rules. My lord, despite this, as I've said, my lord, I'm retiring on 31st June 2025. Only 8 months left, my lord. Now, close, my lord, see, close D, 1D is, my lord, have seen.
No, it's 31st June 2025.
25.
But this order is 23.
No, my lord. I'm coming. This impugn order, my lord. That's
where's the
impugn order is, my lord. The impugn order at page 29, my lord.
29.
Yes, my
Okay,
lord.
so your
That is,
transfer
my lord,
order-
within one, after
Okay.
hardly I completed 1 year, even not my normal tenure has been completed. At page 29, my lord. This is the impugn order, my lord. 15 October 2029, issued on 17 October, my lord. My names appear at 3, my lord.
So you have been transferred to which place?
From Longding division, my lord. From Balijan, Doimuk division to Longding division, my lord. Different district, my lord.
Okay, so you want to remain in Balijan?
Yes, there's a categorically rules, guidelines say that I'm at the verge of retirement and more of my tenure.
You have 8 months. left.
8 months, my lord. 8 months left. And my lord, tenure, I have not completed. 2 years tenure, normal tenure, I have not completed, where government has already directed to maintain this, strictly follow the guidelines, my lord, regarding tenure, my lord. Now, my lord, see how this impugn order has been generated. My lord will see at page 33, my lord. I have annexed the file noting as well through RTI. Page 33, my lord. Page 33, note 74, my lord. The query, when this proposal for transfer was put up, the principal secretary of the PW department put a query about the tenure and detail, my lord. Page 74. Now the 74, the answer to this 74 query, my lord, at page 34, my lord. Continuation of 74 note. Sri Koz Tarang was posted to Balijan on Shonso, 15 June 2023. 1 year only. Since Koz Tarang Shonso has not completed normal tenure at Balijan, litigation is likely to be invited in the event of his transfer from Balijan, my lord. Now, this was the query, reply to the query made by the principal secretary. Now, the principal secretary, my lord, upon this query, what is the comment of the principal secretary at page 35, my lord? See. Principal secretary, the comment of principal secretary at note 79, my lord. 35, my lord. Koz Tarang hasn't completed his tenure of 2 years in Balijan. His transfer is avoidable given legal precedents, my lord. My lord, despite of this is the authority have decided, right from the deputy secretary and even entire authority department. Now, despite of this finding, opinion, comment given by the principal secretary at now down below note 80, my lord. Note 80, the advisor to the minister concerned, my lord. What he said, as desired by Honorable MLA Doimuk and Honorable MLA Chiang Tajo, AR Hano Yangfi A may be posted as A Balijan subdivision and approved as proposed. My lord, This is the private respondent. Now here it's entire mallet file noting. It has not been initiated on the administrative exigency, but only to accommodate this private respondent, that at the desire of this both MLM, which absolutely there's no element of public interest. There's no administrative exigency. Now this accurate directly to this point, hitting this point, my lord, the recently a division bench dealing with the transfer at the fag end of the service career at the verge of retirement. The division bench of our High Court has been an occasion to deal with this aspect. My lord, para 7, just already I have highlighted it. Para a background of the fragment. The contention of the appellant writ petitioner is that impugn transfer order dated so at the fag end of his service career is grossly illegal. The appellant writ petitioner is completed only 1.5 years as executive engineer PW Longding Division, as normal tenure is 2 years. The further contention of the appellant is that the impugn transfer order dated so has been issued in a gross violation of clause D, regarding that no transfer should be made before 1 year tenure of retirement. Issued by the government of Arunachal Pradesh. The clause D in a clear terms mandate that officers are not to be posted 1 year before the retirement, as it may affect the preparation of a pension paper. The appellant writ petitioner is due to retire from his service only 10 months service left at the time of the issuance of impugn transfer order. It is further contended that the appellant has been sought to be transferred only to accommodate the private respondent 3 without there being any public interest or administrative exigency. The impugn transfer order dated and its consequential order are gross violation of the guideline regulating the transfer and posting of the official in the state of Arunachal Pradesh. Now this is the factual background. At page 22, my lord.
Para 22.
Yes, para 22, my lord. On perusal reading of aforesaid circular, it transpired that the officers are not to be transferred 1 year before retirement, as may affect the preparation of their pension paper. The circular number dated may be a policy guideline having no statutory force, but is a professed norms followed in the state of Arunachal Pradesh, which regulate the transfer and posting of the officer and staff in the Arunachal Pradesh. 3 months. It is undisputed that the appellant petitioner has been sought to be transferred by the impugn transfer order dated to before completion of normal tenure of 2 years and before 11 months from date of retirement, which is stated to be short. On careful consideration of submission of the parties and material available in record, we find that no public interest and administrative exigency is discernible in issuance of impugn transfer order. We also find that consequential rejection impugn order the respondent has sought to justify that the transfer order of the petitioner will facilitate the petitioner in submission of pension paper as the director, account, and treasurer is also in the state capital, which is not supported by any material. Available material on record does not reflect anything as such justification while issuing transfer order. Now, in this case, even the headquarter, but in my case, that has been to the other district, my lord. Now, para 31, my lord. Para 31, my lord. 31. Reverting back to the present case, as noted above, the reason of transfer and posting, the appellant represent and sought to be justified by the respondent authority are twofold. First, the petitioner has been sought to be transferred as to facilitate him the preparation and submission pension paper for timely release of pension benefit after his retirement. Now, since it's related to our part, now again, next, my lord, on this point, my lord, how the division bench deal with We also take note of the fact that circular dated 02/1998 may not have legally enforceability. However, since it is a professed norms followed in the state of Arunachal Pradesh regulating the transfer and posting of the officer and staff, same cannot be lightly discarded on the ground of legal enforceability. More so, it is the nobody's case that even if there is a violation of policy guideline, it does not have any legal enforceability. Rather, the London Council for the parties have contended and attempted to interpret the clause D, 1D of the circular dated so in support of the respective cases. Consequently, my lord, the impugned transfer order set aside. Now, in this case, my lord, to accommodate the particular person, the transfer order, whether it is a public interest, whether it is a tenable or not. In this regard, also, it has been well settled, madam. I'm submitting to the point that the transfer order issued only to accommodate the private respondent at the desire of the politician is utter illegal and a malified malord. At page para 13, malord. Para 13, 14, para 13, malord.
Yes.
In the same case, so, malord, so, it has been held that transfer order which is made to accommodate another employee is not bona fide exercise of power. Similarly, in the case of so, the division bench of Bombay High Court held that mid-term transfer affecting only to accommodate another person, another employee will be malified. 14, minor. In the instant case, petitioner was transferred only to accommodate the respondable. 5. Her application praying for a transfer to the school in which the petitioner has been working received immediate attention, and she was favored with the transfer order at the cost of petitioner. Para 17. Transfer order issued as in the instant case only to accommodate another person, and that too without affording any opportunity to the person whose interest is affected cannot be said to an order issued in administrative exigency. For the reason, foregoing reason and discussion, I have no hesitation to hold that impugned transfer order that has not been issued in any public interest, but has been issued only to accommodate the respondent 5, and in the process, the aforesaid transfer guideline came to be violated. Consequently, impugned transfer order that is stands set aside and questioned. Madam, my case is in the both cases is squarely covered, madam. Therefore, at this stage, my humble submission, madam, that impugned transfer order may be stayed, madam.
Yes. You'll issue notice first.
And moreover, madam, my even pension preparation already started in my place of posting, present place of posting, madam. See at my also next at page my last page 38, my lord. My pension paper has already been started and Daimuk division, my lord. But the whole purpose is to safeguard the pension preparation, my lord. If it is I'm transferred out, my lord, I'll be jeopardized, my lord. Page 38. It has already started on 30 September 2024.
So this place, this Baligan subdivision, it
Yes,
is in
under
the-
Daimuk division, my lord.
Under the?
Under this Daimuk division, my lord.
Okay, so it's
Yes,
within
yes.
the main headquarters.
Yes,
Okay.
headquarter. Now
Okay.
from headquarter, now my pension papers already started.
Ah, And his transfer order, impugned transfer order dated
Page 29,
15
madam.
October
Yes,
2024.
yes.
He is going to be transferred to which place?
From Balijan to Malot, Longding division.
Okay, Longin is somewhere out.
Yes, outside, madam. It's a different district, madam.
Okay, fine. I heard Mr.
Tabar Tagum, madam.
Tamil
T.
Tagum?
Tagum. Tabar.
Yes. Learned counsel for the petitioner. The instant writ petition is filed challenging the transfer order dated 15th October 2024, wherein the petitioner is being employed as the assistant engineer under the Arunachal Pradesh Public Works Department was transferred from Balijan PW subdivision to as instead of to as ASW
Longding Division.
Longding Division. Full stop. Okay. The Learned Council submits that the petitioner was transferred to Baliganj subdivision on 15 June
2023.
2023. And thereafter, the impugned transfer order dated 15th October 2024 was issued, which is in violation of the circular.
Transfer posting guidelines of the state.
Where is it? Transfer, which is in violation of the transfer and posting guidelines.
The state of Arunachal Pradesh.
Wait, where's that?
Page 22, my lord.
Page 22. Guidelines issued by the Department of Personnel. It's not guidelines, it is circular.
It's a circular guideline, my lord.
A circular issued by the Department of Personnel, Government of Arunachal Pradesh, dated 2nd June 1998, wherein it is specifically mentioned at para 1 within brackets D. Okay, that then within inverted commas, officers are not to be transferred 1 year before retirement, comma, as it may affect preparation of their pension papers, comma, etc. full stop. However, comma, generally officers posted in the field/work divisions should be posted out to office headquarters 1 year before retirement. Full stop. Okay, close inverted commas. The Learned Council submits that the instant petitioner is to retire in the month of
31st June 2020.
on 31st June
2025.
2025. And therefore
8 months left.
he has only 8 months left before his retirement.
And
The Learned Council submits that the case of the instant petitioner is a covered matter by citing the judgment of the division bench of this High Court in Dilip K.R. Saikia versus State of Assam and others, reported in 2005 for Guwahati LT 371. Okay. It's GLT, okay? GLT 371. And the decision of the apex court in Pangbong Tanga.
Malad, I'm sorry to say, Malad, this DK Kumar Sharma, Malad, it's a single bench, Malad. And
Okay, I thought you mentioned the division bench judgment.
Division bench, yes, yes. Malad, division bench is Pangpong Tangka, Malad.
Okay, okay. The decision of a coordinated bench in, okay, GLT, that one. Okay, within brackets, principal seat, coordinated bench, principal seat, then reported in GLT so and so. And the decision of a division bench in then Pangbong Tanga versus State of Arunachal Pradesh, reported in 2024 0 Supreme within brackets Gao 214. He therefore submits that the impugned order dated, was it impugned order dated? So and
29,
so,
my lord, page
okay,
29.
29 so and so may be stayed till the disposal of the instant petition. Issue notice to the respondents.
Only tenure part also. I mean, I have not completed my normal tenure of 2 years, my lord, as
Okay.
per guidelines. my lord.
Wait, report it in so and so. Okay. The learned counsel further submits that he has not completed his tenure of 2 years.
Yes,
As per the notification
transfer-
slash circular dated
dated, my lord, modified dated at page 27, 18 August.
at page
Page 26, my lord.
26. Okay. His tenure as per the order, okay, passed by the Department of Personnel, Government of Arunachal, dated 19th December 2008. In view of, then so and so, what, after that, the order will be issued notice. Issue notice to the respondents through registered post with AD within 3 days,
My lord.
returnable by 3 weeks, as well as through usual process. Yes. List after 3 weeks.
My lord, interim, my interim, my lord. Impugn order,
Okay.
my lord.
Meanwhile,
Well.
on considering the submission made by the learned counsel for the petitioner, this court finds it fit to pass an interim order for stay of the impugned order dated so and so till the next date of listing. Yes.
In respect of the
Petitioner and the private respondent.
Serial number 2 and 3 laws.
Mm.
One is not connected to here laws. Impugn order by the impugn order, 3 persons have been transferred laws.
Impugn order in
Okay.
respect
It
of
may be
The
given
impugned order so and so
In
in
respect
respect
of
of
petitioner and
the
a private
petitioner.
respondent. Yes, petitioner and a private
Private
respondent. Private
Okay,
respondent number 3,
private and the private respondent number
3, my lord.
3. Okay, the
Others
rest-
are not connected, my lord. That's deeply applied.
yes.